Lordship's kind permission. Lord, one matter, Lord, I have filed vacating IAM, Lord. I am representing for authority, Lord. The road work has been stalled, Lord, because of the interim order. Lord, I request, Lord, to have this next week any day, Lord.
Give it.
Milords, there's a pending GST matter where the same authority has conducted audit and adjudication. Milords, it may be taken up tomorrow or next Tuesday.
Let us see. Give it.
Milords,
Give it fresh matter.
pending matter. Milords.
Let
Last time
us
we
see.
took an adjournment.
We'll take it up. There's already interim order.
No, Milords, no interim order is granted.
Preliminary hearing list. We'll consider the interim order.
My Lordship, it's an MPMLA matter, my Lordship, pending before the trial court, my Lordship. It's an investigation, direct the matter to the CBI, my Lordship, seeking direction to investigate.
Give it. We'll have. Next week we'll have.
Obligation.
Your Lordship, land acquisition matter, Your Lordship, after 40 years of land acquiring, the landowners have come and again challenged it. We have put an Impleading application, Your Lordship. Kindly have it next week.
Your Lordship, the matter has already been disposed of on 9/7/25. I need some clarification regarding the interim orders. The matter may be taken up tomorrow.
Mandamus, my Lord, 2018 matter. Kindly posted next week.
2018 matter.
No, 2000, writ of Mandamus only.
Preliminary hearing list.
Minute from Mandamus is directing the respondent to consider representation
Fresh matter.
of old matter.
Put it. Preliminary hearing list. Mandamus.
My lords, pending matter, my lords. What's happened is there's an interim order operating against me under which I can't continue certain construction. This is causing a lot of disturbance because it's created a bottleneck. A date may be fixed in this matter, my lords.
Date.
My lords, on criminal petition, fresh matter, my lords. Any date may be fixed, my lords.
Special roaster. Special roaster.
Fresh matter.
Special roaster.
Yes, my lords.
May it please my lord, I'm appearing on behalf of the petitioners in serial number 53 today. The ASG is appearing. It's a matter of
Page-wise. Just wait, page wise.
Adjournment,
Make a mention with the matter. Yes.
Page number 1, 1 to 5. Page number 2, 6 to 11. Page number 3, 12 and 13. Page number 4, 14 to 20. Page number 5, 21 to 28. Page number 6, 29 to 32. Page number 7, 33 to 36.
34 and 35 pages, 1 week time.
34 and 35, list 1.
Please.
Sayyad.
At request, list week after next. Necessary steps to be taken. Necessary steps to be taken for issuance of now R1 and R2 are government.
R1 and R2 copies have not been served in serial number 8428.
Correct. You will accept notice for the respondents.
The respondent number 4 is a private file.
1 and 2 are government
One,
parties.
two are government. For them, I have already taken notice.
Yes.
Copies
Steps to be taken for issuance of notice to R3 and R4. Same order in 35. Copies of petition to be served on Government Advocate A.G. Hen Kumar. Yes.
Page number 8, 37 to 42. Page number 9, 43 to 47.
My lords, 47.
Yes.
This we have a stay, but this matter is pending before the DB. So I'm just praying for the extension of stay and can be listed after 3 weeks. This is regarding that unsigned sanction.
List after 2 weeks. Interim order earlier grant is extended to the next day.
Yes. Page number 10, 48 to 51.
My lord, I'm appearing for the petitioners in 53, my lords. My lords, in this, the pleadings are complete. This petition challenges the constitutionality of the limited interpretation of the term relative so as to exclude same-sex couples from the income tax exclusion that is given to relatives for gifts between relatives. And while spouses are indeed included in the definition of relatives, it is not certain whether same-sex couples would be included in the definition of a spouse. It is our contention that in light of the Supreme case...
Now you want time or what is it?
No, we would like to have a specific date on it. It's listed for today. But my lord, the pleadings are complete. I've discussed it with the ASG who's appearing for the union. that we're both available in the week of the 17th of March. So if it can be kept at 2:30 p.m. on the 17th, my lords, it would be very useful for the matter to be heard and disposed of.
I'll give it, but before coming, you will have to recheck because there may be change of roster. There may be a change of roster. I'll give the date of your request, but before coming, you have to cross check. Please find out.
My lord, it might also be possible to do it on the 10th, in the week of the 10th of March.
I'll give a date, but I'm saying before you come, if you appear on VC, there is no problem. If you are going to come, please check with the registry before you make your travel arrangements.
My lords, I'm obliged, yes.
At request, release the matter at 2:30 on 10th.
10th March.
Yes. You
10 March or
both,
18 March, yeah, obliged, my lords.
Both sides to file their synopsis in advance consisting of a list of dates, summary of legal contentions and legal authorities relied upon. After serving, advance copy on either side. Yes.
Page number 12, 56 to 57. List 2, page number 1, 1 to 6. Page number 2, 7 to 14. Page number 3, 15 to 24. Page number 4, 25 to 33. Page number 5, 34 to 40. 35.
It's covered, my lord. So one, CP Vivekanand, my lords, with the permission of this court. It's covered, my lords. Notification is planned.
Let us see when it reaches.
In advance, my lords, I'll serve the copy on TP Vivekanand.
Yes. Let us see when it reaches. You serve it.
I'll serve them.
Yes.
Page number 6, 41 to 46. Page number 7, 47 to 49. Page number 8, 50 to 54. Page number 9, 55 to 59. Page number 10, 60 to 65.
My lords, I'm appearing in serial number 60. I'm for the petitioner in serial number 60. May I request for a week's time, my lords, to comply with, to do the needful.
Have you informed the other side?
My lords, it is all state in its instrumentalities, my lords.
There are others also. National Highways Council is there. You have to inform.
Mr. Shobhit Shetty is present on video conferencing, my lords. I believe he is on record for NHAI, my lords.
It's your responsibility to inform. I don't want the other council to come and say, I was not informed. I will accommodate your responsibility to
I will inform. I will inform, my lords.
I don't want any other lawyer to wait.
Please, my lords, please.
Week's time granted to take necessary steps for issuance of notice to R4 and R5 this week after next.
Page number 11, 66 to 72. Page number 12, 73 to 74. Page number 13, 75 to 77. Page number 14, 78 to 81. Page number 15, 82 to 85. Page number 16, 86 to 90. Page number 17, 91 to 95. Page number 18, 96 to 100.
My lords, I appear for the petitioner in serial number 99. I pray for a short accommodation to file the rejoinder, my lords. A date may be fixed. It may be had on Monday, my lords.
My lord, I object for any adjournment or for the respondent Kate if they are enjoying the benefit of interim order. In this last date only, it was directed for them, my lord. It's a petition challenging 28(3) order, my lord. Object for any adjournment, my lord.
My lords, it may be had on Monday. I'm only asking for a short accommodation, my lords.
There's already 2 weeks time were given, my lord. 2 weeks time were given, and last time.
Let us see.
Please.
As a last opportunity.
My lord, let it come in the due course, my lord, because the property is already, my lord, it's between the allotted area, my lord. That's the difficulty, and I have an interim order, my lord.
My lords, I'm
and already 2 weeks time was given last time.
You want it to be disposed of or not?
My lord, there are two matters, connected matters, that 98 and 99, my lord. AG is appearing in this matter.
Which list, sir?
List 2, my lord. Serial number 98 and 99. Both are challenging the 28(3) order, my lord.
You want short date or long date?
No, my lord. I don't want an adjournment in this matter, my lord.
You don't want.
Don't want
so
an
I'm saying we'll give a short accommodation, and then on that date you be ready. Relist on Monday. Rejoinder, if any, to be filed by the petitioner by the next date, 98 and 99. Yes. If you are seeking for Vacating, you have to file vacating.
We have
stay.
already filed vacating TA also.
Where is
No,
your
my
right?
lords, they have not
IA has
filed a
been
vacating
filed.
stay in serial number
It's
99.
not shown. It's not shown in the list.
Please will put up.
19, 1012, 103.
My lords, 102, one small mention, my lords. This is a fresh matter. This was posted today for the department to take a instruction.
Tanmati.
We only prayed for a remand. So this has gone to B group. My only prayer is, can it be called after 41 minutes? It's a fresh matter. Sanmati. He has a matter at 14. My lords can call it along with that also. No issue. It's a fresh matter. Only for a remand.
After fresh matters.
Please. Apply.
List 2, fresh matter serial number 1, Viresh R.
My lord, I seek my apologies. My lord, in list 1, serial number 12, I seek for a short accommodation.
At request. Have you informed the other side?
Please, my lords, I have informed. I have not yet received instructions.
No, but this we heard it last time.
I should.
When it reaches you make, I will accommodate. Yes.
Please.
List 2, serial number 1, Viresh R.
To be corrected with my lords, WP 10971 of 25, my lords. I may be permitted to serve a notice on Sri Ravi Shankar, my lords. Ravi Raj, my lords. Yesterday, similar matter was posted, my lord.
Land Council, Sri YV Raviraj is directed to accept notice for respondents for the respondent. List along with the WP number
10971, my lords. I'll write it, please. 25.
Serial number 2, Lakshmi Menon.
My lords, GST assessment for the year 17-18, my lords. In this case, what has happened? First, my lords, the central tax issues me with a show cause notice, which culminates, my lords, in an order.
Just a minute. Who appears?
Arvind sir could appear, my lords, a central tax matter.
Chavan. Where is he? I'll pass over in the same. Immediately after fresh matters, I'll take up the passed over fresh matters.
Please.
You wait. Pass over.
I just inform.
Nataraju T.
In this case, not challenging the Malad award passed by the KADB Malad. There are Malad, multiple proceedings are pending between the parties. Despite of that Malad, the KADB Malad passed an award in favor of the Malad, the private respondent. Malad, the material records Malad very clearly goes to show that Malad, multiple proceedings, including writ appeal, writ petitions are pending. The 4D Malad, which was entered, that itself is Malad a fraudulent act. 4D cannot be entered into the city area. A suo motu proceedings initiated against him. The officer who passed an order, he personally involved with the private respondent and released the amount.
Okay, you take out notice.
Please.
2 and 4, my lord, I have filed wakalat. Except 2 and 4, they have to issue.
Notice to be issued to the rest of the respondents. 3, 4, 5 notice.
Where is the cost title page?
Please, 20 and 21, page number 20 and 21.
Ashok and Naik is accepts notice for respondents 2 and
2 and 4, my lord, I have filed.
2 and 4.
Yes.
Emergent
So
notice
for
to the third respondent. AGI,
1, 2 and 5 notice has to.
1 also you can accept. KADB.
My lord,
KADB.
KADB source, my lord, it has to be.
You have to check
mentioned
the
as state of Karnataka.
you have to correct
Government
the,
only, I think.
You have to correct the description of the first respondent.
Please.
AGI accepts notice for the first respondent. Make it a Secretary Commerce and Industries.
Please.
Principal Secretary has made, my lord, but state of Karnataka, instead of state of Karnataka, Karnataka KADB is mentioned.
No, sir.
I'll make correction, necessary corrections.
Petitioner is permitted to correct the description of the first respondent. Now KDB also is required, so then it will be different description.
3 and 5 notice is required.
No, just 1 minute. Now he has made a mistake. He wants to implead KIDB and the state. So let him correct the description of 1 as
Yes.
KIDB represented by its managing director. Just point out. 2, let him make an additional respondent as government.
Please. Please.
Petitioner is permitted to implead the Secretary Commerce and Industries Department as an additional respondent. And also is permitted to correct the description of the first respondent.
Not one submission. I have filed wakalat for respondent number 4. In fact, respondent 4 is nothing to do with this compensation only land question.
Correct. That we'll see. That we'll see.
Yes, that is
So
the,
far as
anyway, I
for-
have filed wakalat, my lord. I have filed
So far as 3 and 5 are concerned, well, notice has to go.
Emergent notice to 3 and 5.
Please.
Now you carry out the change now.
Please,
itself.
sir. Please.
You just did.
Please.
4, Mahapati.
Correct my confusion.
My lords, I'm appealing for the petitioner. The matter may kindly be passed over, my lords. Counsel is held up in answer.
Pass over.
5. Serial number 5.
My lord, ex parte order passed by adjudication officer. Also, hearing also not given. Kindly given opportunity to proceed.
That is the why you did not appear on that day. Some reason must be there. Where is the
All
order?
hearing also not given.
Where is the order? Page? Annexure?
Annexure A, page 20, my lords.
Where is the order, sir? Where is the order of adjudication?
Annexure A, page 20.
Annexure A.
Huh. Now you take me to that order. You point out where. A is the summary. Where is the order? But where is the order in original? You produce that. I'll have it on next Tuesday. Where's the order in original? Relist the matter. Same stage.
Part of the order has been produced. Page 24.
Page?
24. They probably missed out on some sheets.
No, it says summary of order, isn't it?
No, page 24 would be part of an order past the main order.
Order copy attached it.
They've missed out on the first two pages or 3 pages.
Now you produce it. Relist on Tuesday. Yes.
6. Serial number 6. Vishwanath Patil. 6. Vishwanath Patil.
16-2C matter, my lords.
16-2C
matter, 10% of the tax.
My lord.
So we'll state you must pay 10% of the demand.
My lord.
We'll state you pay 10% of the demand.
This is an ex parte order, my lord, and the issue is it is a time barred case, my lord.
No, but are you challenging 16-2C?
18 and 19, the order should have been passed on 31/12/2023, whereas this order is passed on 15/4/2024, my lord. There is, of course, central government has by notification extended the limitation period up to 30/4/2024, my lord.
Up to
And this
30th.
matter is pending before the Honorable Supreme Court.
Correct. Now, if you are challenging validity of 16-2C, then they are saying as a matter of procedure in other matters, we are saying you pay 10% of the tax demand. We'll stay it till the apex court decides. If you want to go back, then we'll look into it. Then you have to give up your prayer of challenging 16-2C.
Matter may be remanded back, my lord, with the direction they pass a fresh order after the passing of the Supreme Court. Similar cases, in similar cases, it has been done.
Yes, what?
Order is dated 15/4/2024.
2024.
That is the reason, Mother, the division bench in the first matter where there was a challenge to section 16-2C. Then, Mother, the matters pertaining to challenging the validity of a provision was to be listed before the division bench. The then division bench, Mother, said in the guise of challenging the order, they're challenging the validity. So it is appropriate to ask to direct the petitioners to deposit 10% of the tax. Following the order passed by the division bench, Mother,
Now you pay 10% of the tax demand. Anyhow, that will be adjusted subsequently. So,
they have not
No, now-
they have not participated in the proceeding.
no, he's
Let them
agreed.
pay 10% and matter may be remanded.
Sent back.
That
Where is the order?
Orders are annexure B, page 32.
Annexure B.
Now, what is the
Page number 32.
so reconciliation between 2A and 3B?
Yes, my lord. Yes, my lord.
The
That's only
petitioner.
that.
You can simply have one scheme. All those who want remand pay 10% and go back. Everybody will come. At least 10% before budget.
At least merge, the department also should be a little satisfied that getting the 10% amount which they would have got if statutory appeals would have been filed.
The petitioner.
The entire work has to be redone. That is, apart
Yes.
from doing the latest assessments and adjudications.
Petitioner has called in question the correctness of the order of adjudication at annexure B dated 15/4/24. Full stop. Petitioner has also challenged the validity, constitutional validity of section 16(2)(c) of the CGST/SGST Act. Full stop. Next, when the matter is taken up for consideration and counsel for the petitioner submits that he does not intend to insist on adjudication as regards his prayer to declare section 16(2)(c) as being violative of the constitutional provisions. Next,
And also the validity of notification.
as well as validity of the notification. Full stop. Insofar as plea regarding setting aside of the order at annexure A is contended that the order of adjudication has been passed by way of ex parte order and the authority did not have benefit of reply to the show cause notice of the department. It's further submitted that insofar as the reconciliation between GSTR 2A and the input credit claimed in GSTR 3B, petitioner has material to demonstrate such a discrepancy, to demonstrate that the discrepancy as pointed out does not exist. Full stop. It is submitted that the court may set aside the order and remand the matter back to the stage of reply to the show cause notice. And AGA submits that the order is passed ex parte only due to the lapse of the petitioner in not diligently participating in the proceedings. However, it is submitted that if the court were to pass any order of remand, court may insist on the petitioner paying 10% of the tax demand. Next. Taking note that the order passed is an ex parte order without benefit of stand on merits of the petitioner to the show cause notice, and also noticing the stand of the petitioner that they would be in a position to explain the discrepancy between the ITC as reflected in GSTR 2A and the input credit claimed under GSTR 3B. It would be appropriate to set aside the order of adjudication and remit the matter back to the respondent number 4 for adjudication from the stage of reply to the show cause notice. Full stop. Petitioner to appear before the respondent number 4 without further notice on
16th of March.
Needless to state, if petitioner is absent on the said date, petitioner would forfeit the indulgence granted by this court by virtue of this order, petitioner to pay 10% of the tax demand. Accordingly, the order at annexure B, isn't it? Yes. Is set aside and matters remitted in terms of the observation made above. AGA M. Kumar accepts notice for the respondent.
Regard to their giving up the prayer with regard to challenge validity under notification.
That I've stated that.
Please.
Has given up at the outset. He gives up the prayer insofar as 16(2)(c) and the notification. First sentence. Yes.
7. Akshita Shetty K.
Milord. Same property owned by the petitioners for notifying it for the second time after an award has been passed in respect of the one acquisition, Milord. In the year 2021, 19.
Take out notice.
Milord, I am seeking for stay, Milord. It is a building.
Correct. So you serve. We'll have it Friday. After. We'll have it on Friday. You serve.
Yes.
Union of India. The land acquisition. So and so is directed to accept notice for the first respondent, AGA, for 2, 3 and 4. 2 and 3. 1 and 4. DSGA directed to accept notice for the first and fourth respondent. Relist the matter in same stage on Friday. You serve copies immediately. Yes.
8. TS Venkatesh.
The acquisition was in the year 1971 and still now we are in possession, Your Lordship. We have produced a kata of the year 1998 and also of the year 2004 and 2018. And present e-kata is also available in your name, in my name, Your Lordship. And Your Lordship, and the vicinity of this 5 acres is still with the third parties. Though this may I take Your Lordship to.
So let us see. You serve copy. I'll give you.
May I beg Your Lordship to page number 15?
No, I'll hear you. Yes, I'll consider. Yes, you serve it. I'll immediately have it on Monday.
Monday.
AGA accepts notice for first respondent. BDA. K. Krishna for the second respondent. Release the matter in same stage on Monday.
9. Serial number 9. Narendra Kumar. Jayanti Lal Jain.
Yes, income tax.
Lordship, I will take notice for respondent number 2, Milord. Respondent number 1, Arvind Chavan, Milord.
Council Arvind Chavan directed to accept notice first respondent. EI Sanmukhi for the second respondent. Yes.
My lords, this is a petition to challenge annexure E, my lords. Annexure E, my lords, is an order passed to invalidate, it's at page 42, my lords, the Central Processing Center, respondent 1, my lords, as invalidate my return, my lords. The reasons for invalidation are given in the box, my lords. It is stated that the taxpayer has offered gross receipts or income under the head profits and gains of business or profession more than 10 crores. However, books of accounts are not audited under section 44AB of the Income Tax Act, my lords. My lords, section 44AB of Income Tax Act, my lords, provides for audit of books of accounts. It provides the limit of a turnover. If the turnover exceeds a particular threshold, then the audit of books of accounts needs to be done, my lords. The limit as applicable to me is 10 crores, my lords. My lords, in my case, the limit is, the turnover is below 10 crores, my lords. My lords, this can be found out in the financial statements, my lords, which is at annexure F, my lords, page 44, which starts at page 44, my lords. My lords, what is happening in this case, my lords, is the profit and loss account, which is there at page 46, my lords. If my lords see, the revenue from operations is 8.94 crores, my lords. My lords, I am in media channel, entertainment channel. I get advertisement revenues, which comes to 8.94 crores, my lords. My lords, I also have other income of 33 crores. Now, out of that other income, my lords, the breakup of which is given at page 54, my lords. The major part at page 54, if my lords have schedule 17, other income, 30 crores come from sale of movie rights. Now, sale of movie rights is a sale of an asset, my lords. Now, a sale of an asset, it does not constitute turnover. As per a Supreme Court decision, my lords, and the ICI's guidance note. So, when this is excluded, the turnover falls below 10 crores and I am not liable to get the tax audit done, my lords. This aspect, as though we have given in the response, my lords, in Annexure B, we have given a response, Annexure C, my lords, where we have highlighted.
Yes.
Has not been considered by respondent 1, my lords.
Your Lordship, respondent number is central processing unit. Your Lordship, it cannot be redone. It is computer generated one. Your Lordship can direct the second respondent jurisdictional assessing officer to verify the claim of the assessee and forward the report to the respondent number 1. The response filed by the assessee, my lord, let them appear before the second respondent and make their submissions, and he will consider the claim of the assessee that whether 44AB audit report is required or not, and he will take a decision and forward it to the CPC, that is first respondent.
We will dispose it of.
Yes,
The petitioner has sought for setting aside of the impugned order at Annexure E and has also sought for a direction to the respondents consequent to setting aside of the order at Annexure E to process the return of the income of the petitioner for the assessment year 2024-25. The case of the petitioner, that the petitioner is aggrieved by the order invalidating the return in terms of Annexure E with the observations. Taxpayer has offered gross receipt of income under the head within inverted comma profits and gains of business or profession close inverted comma more than 10 crores. However, comma books of account are not audited under 44 capital AB of Income Tax Act. Next. In the case of the petitioner, that the turnover of the petitioner cannot be construed to be above 10 crores in light of income of the petitioner, part of income of the petitioner being exempt.
No, my lords, it is a sale of asset, and sale of asset cannot be classified as turnover, my lords.
As the part of the income of the petitioner is constituted of sale of assets which cannot be construed to be turnover. It is submitted that petitioner has material to demonstrate such contention and assertion which would have the eventually lead to his income being less than 10 crores.
My lords, turnover being less than
turnover being less than 10 crores. Next, Honorable Counsel Sanmati appearing for the second respondent would submit that this is the communication at Annexure E is computer generated from the centralized processing center, and the court, taking note of the stand of the petitioner, may direct the second respondent to hear the petitioner and forward appropriate report thereafter to the first respondent. In light of the said stand and taking note of the contention of the petitioner, the order at annexure E invalidating the return is set aside. Matter is remitted to the second respondent. Petitioner to appear before the second respondent without notice on
16th of March.
16th of March. Petitioner then to demonstrate that the requirement that the turnover of the petitioner is less than 10 crores and question of audit under 44AB of the Income Tax Act would not apply. With a further request that consequential to such explanation, the second respondent may forward the report to the first respondent. Please. Accordingly, petition is disposed of.
My lords, a time limit may be given to process the.
No, my lord.
And my lords, 3 months or whatever. My
That will see. Now you just tell Arvind now. This.
Yes.
Please.
Yes.
10, Shrikant NV.
On the petition.
I filed Vakalat on 10th of February for respond number 2 and 3. My name is not shown in cause list. So direct the registry to show my name.
Yes. What is the matter?
That's a challenge of final notification, my lord, issued by the first respondent. Dated 22/7/2005. Similar matters, my lords, as per annexure G.
Annexure?
G, my lord. Page number, my lords, 39. In respect of same survey number, my lords, the.
Why everybody has to come to court? You just give it up, no?
I'll get
You're
the
not-
instruction. Let him serve writ papers.
No,
Yes,
what
please.
I'm saying. Why every petitioner must come, spend money and then get it set aside? If it has been abandoned, let the government take a policy decision.
So government, once the notification in respect of some survey numbers, preliminary notification is quashed. So it is for the state to make the
Correct, that you take a
same
call.
order to the
More
entire.
than- More than 20 years have lapsed. If it's not progressing, you take a decision, leave it, abandon the project, you take up some other project. Annexure?
Annexure G, my lord, page number 39. In respect of similar survey number, my lords, the
Same
petition was
notification.
allowed.
Same notification.
Please, my lord. Same survey number, same notification.
So see why they have to come. You can just, might as well take a decision at your end.
That's operative portion, my lords, in page 24 of the judgment.
This matter next week. In the meantime, let him serve writ papers.
I'll serve the copy.
He has not
CCM
served.
CCMS
I'll serve the
ವಕಾಲತ್
copy.
ಕೊಟ್ಟಿದ್ದಾರೆ.
GM Anand is directed to accept notice for the
two and
2 and 3. AGF first respondent. Relist the matter in the preliminary hearing list on
25th.
Yes.
11, Atul Krishnarao.
Appearing for the petitioner, my lord. My lord, this is the case where multiple assessment, a single order has been passed, my lord.
Yes, GST.
State of Karnataka is a formal party. For respondent number 2, I'll take notice. Serial number 11.
AG accepts notice for the second respondent, Union of India. Madanand Pillai for R1. 3 and 4. G1 Niralgi accepts notice for respondent 3 and 4. Division bench is hearing this question. This division bench is hearing this question, is it? Where is the tax
My
period?
lord, page number 71.
I think today afternoon.
Page number 71 shows notice, my lord, at annexure D. And it can also be seen at the order in original at page number 89.
In light of the contention that the single show cause notice has been issued relating to multiple tax periods, as is evident from the table at para 9.3, petitioner seeks for relief, placing reliance on the order of this court in Pramur Homes and Shelters. In light of the contention raised, there would be stay of
Annexure F, F1 to F6, my lord.
nature F, F1 to F6,
F5, my lord.
F5. Given there is list week after next.
12.
Appearing for the petitioner, my lord.
IA 1 of 26 is now the insofar as the IA is concerned,
Yes.
you have downloaded from the portal.
Yes, my lord.
IA 1 of 26 is allowed petitioner dispense with production of certified copy of annexure EF F1 to F5 in light of the contention that the documents are downloaded from the portal.
12. Atul Krishna.
Appearing for the petitioner, my lord. My lord, this is the case where there's a differential tax amount, my lord. As per the works contract that has been issued to the petitioner.
Now, who appears, state or central?
State is again a formal party.
Learned Counsel G1 accepts notice for respondent 1, 2, 1, 2. 4, 5. AJ accepts notice for the third respondent.
Third respondent, I think.
Third respondent.
There are other respondents.
4 and 5?
No, 4 and 5 I take.
Correct. Then other notice must go, is it?
Yes, my lord.
Just one.
Respondent 6 to 15, my lord.
But these all are state authorities.
State authorities, but there are other some irrigation department, national highways, national state highways.
Will issue notice. Emergent notice to respondents, to the other respondents. Yes.
My lord, may have a look at annexure F, my lord, at page number 81. At the last line, it says 12% GST shall be paid to the tendered amount separately, my lord. So as per the works contract, it is 12%, my lord. But they're charging 18%, my lord. And because of which the demand has been created.
On what ground?
On the ground that the 6% amount has to be paid by the petitioner, my lord.
This, now, where is their demand?
My lord, the demand is at
This pre and post or government, predominantly government. Demand at page?
Demand at annexure E and E1, my lord.
Page?
79 and 80.
Where is the rate now?
My lord, the rate of tax
is 6%.
D1 was only summary of the orders.
1 second, my lord. The order in original is at page number 52 at annexure D and page number 54 para 2, my lord. At the second line, my lord.
Now, how do they charge 18%? What is your, on what basis you're saying 18% is wrong?
My lord, as per the works contract, we are liable to pay only 12%, my lord, which is at annexure F that I showed you previously.
That how is that relevant, madam? That is your work.
We read the entire, my lord. It was 12% earlier.
Yes, my lord.
In between for 18%. For a short period. For a short period.
So this is during that time.
During that time,
yes, my lord.
That's what we have mentioned in the order. He is observed there, from 1/1/2022 to 31/7/2022. Period.
It was 18%. Now, how are you saying it should not be 18%?
My lord, when the work contract was signed, we signed it for 12%, my lord.
No, what they say that at the time of entering into a contract, the rate of the tax which was stipulated in the contract was 12%. So the same should be continued irrespective of change in the rate of tax.
So we'll consider it. Shall we state?
Now, my lord, if that is the only grievance,
The statutory this cannot.
Correct, correct. Correct.
18% will not increase for.
No, this doesn't come within the purview of that Mars case. No. May not come. Because courts have been very liberal by asking them to redo the contract.
At least, my lord, that indulgence is given to them. That indulgence is given to them. At least they should have approached the authorities. They should have taken the benefit of it.
That's
None of them have approached.
That's why they've come second time to the court. Okay, so now what do we do? They suggest. Shall we? You take instructions and we'll.
My lord, in fact, we have represented, my lord, but they've not considered the representation, my lord. It's at Annexure G at page 93, my lord.
Okay, we'll hear the matter. Let us see. The petitioner contends that the demand of GST at 18% is impermissible in light of stipulation in the works contract as well as the date of execution of the contract. Matter requires consideration in the interregnum. There would be stay of the demand at annexure E and E1. Respondents to take the stand in writing within a period of 2 weeks. Yes.
13, Manohar, N.
This is I'm challenging the annexure F Millard, the best assessment order without producing the books of account. My auditor is unable to. He has requested the authority, but they could not give a time. So, and they passed an ex parte order without seeing the books of accounts.
Who is the?
I take notice, my lord. I have got the copy.
G1 accepts notice for respondent 1 and 2. List the matter in the same stage on.
14, Ravishankar SV.
Yes.
Came for hearing last time. We filed a writ against a penalty order which has not been disposed by the CIT, but the quantum additions have been deleted. I filed one small 2-page note, my lord, last time. The entire additions.
Why was it adjourned?
Your Lordship, I was directed to verify the claim of the assessor. Your Lordship, in this case, the penalty order has been passed. Now, the contention of the assessee is that though the appeal is pending before the first appellate authority, this writ can be entertained because the additions made in the original assessment order has been set aside in the order giving effect by the assessing officer in after disposal of the ITIT's order. Since additions are deleted, penalty is not leviable. Your Lordship, may kindly see the penalty is levied under section 271 AAB. Section 271 AAB, my lord.
Yes.
Your Lordship, penalty where search has been initiated. This condition is satisfied. Search. This is a case of search. Your Lordship, the assessing officer or the commissioner of commissioner appeals may, notwithstanding anything contained in any other provisions of this act, direct that in a case where a search has been initiated under section 132 on or after the first day of July 2012, but before the date on which the taxation laws second amendment bill 2000 receives the assent of the president, the assessee shall pay by way of penalty in addition to tax, if any, payable by him. Your Lordship, next clause, Lord, a sum computed at the rate of 10% of the undisclosed income of the specified previous year, if such assessee. Your Lordship, there are 3 clauses, Lord. In first one, in the course of a search in a statement under subsection 4 of 132, admits the undisclosed income and specifies the manner in which such income has been derived, substantiates the manner in which the undisclosed income was derived, clause 3, on or before the specified date pays the tax together with the interest, if any, in respect of undisclosed income, and furnishes the return of income for the specified previous year, declaring such undisclosed income therein. Your Lordship, here I am relying upon three contents, my lord. Firstly, there should be a search. It has been satisfied. Second clause, my lord, there should be a statement. One of the first clause is that there should be search. Your Lordship, second clause is relating to admission of income by giving a statement. Your Lordship, another one clause is that he has to furnish the return of income for the specified previous year, declaring such undisclosed income. There are three clauses. Next, what is undisclosed income? It is there in the explanation down below, my lord. Class C, explanation for the purpose of this section. Undisclosed income means any income.
You're reading at?
Your Lordship, explanation, my lord, down below. Explanation A, B, C. Explanation C, my lord.
Yes.
Undisclosed income, any income of the specified previous year, represented either wholly or partly by any money, bullion, jewelry, or other valuable article or thing, or any entry in books of account or other documents or transactions found in the course of a search under section 132, which has not been recorded on or before the date of search in the books of account or other documents maintained in the normal course of relating to such previous year, otherwise not been disclosed to the principal commissioner or chief commissioner or commissioner before the date. Your Lordship, the undisclosed income, Your Lordship, I am relying upon the first clause, my lord, whether it is disclosed in the books of account or not. Second, my lord, whether it has not been recorded. Any income of the specified year, either wholly or fully by any or any entry in the books of account or other documents, transactions found in the course of search. During the course of search, we have unearthed this undisclosed income. First point. Second point, it has not been disclosed in the books of account. Your Lordship, in the present case, not the facts, Lord, the search has taken place on 9/10/2014. Your Lordship, return of income has been filed on 29/9/2015.
Have they declared this undisclosed income?
Yes, my lord. Your Lordship, the return of income has been filed on subsequently after the search. That is on return of income is filed, my lord, after the search, my lord. That is on 29/9/2015. In the return of income filed, my lord, kindly come to page number 41, my lord. Your Lordship, page 41.
Yes.
Your Lordship, in this, my lord, Your Lordship may kindly see the income declared by SSC. Your Lordship, gross total income, deductions, Your Lordship, net tax payable is so and so, my lord.
No, have they declared the undisclosed income in this?
Your Lordship, this is the return of income. Afterwards, 153C notice is issued and assessment order has been passed. In the assessment order, 2 additions has been made. That additions has been subsequently, by order giving effect, that additions has been deleted. The assessee content, since those 2 additions have been deleted, the penalty is not leviable. Your Lordship, now I am relying upon these clauses, not since this unearthing, because of unearthing in the search, this return has been filed by admitting the income. This is undisclosed income.
That by itself is sufficient to levy penalty.
Yes, my lord. Another, my lord, in the course of the assessment order itself, the assessing authority has given a specific finding that the assessee has not maintained the books of account. He has admitted this point, my lord. Assessment order, my lord.
Sanmati.
May I submit?
Just 1 minute. No, but if that is your stand,
yes,
then you take your stand in writing. We'll have to decide.
Your Lordship, the appeal is pending. This has to be considered before the appellate authority. Appeal filed by the assessee against the penalty order, which is pending. Let since the appeal is pending, let the first appellate authority go through these issues, my lord, whether the 271 AAB conditions are satisfied or not. If there was no appeal, then there would not have been any problem, my lord. I would have argued on this by filing statement of objection.
May I submit?
How are you having 2 remedies?
Page 143 for a moment.
140?
143. Annexure H, 141 starts from 141. I'll just read one paragraph. My learned friend read out the section.
No, but then you withdraw your appeal then.
My lords, this penalty was levied before the order was passed. I'll just for a moment read 271 AAB, what my learned friend read out.
I'm only on the point of the remedy now. How can you have two remedies open now?
Please, my lord. Para 9, my lords.
Para?
Para 9, page 143. Two additions which have been made. This is the finding of the same assessing officer pursuant to tribunal. In view of all stated facts, explanation submitted by the assessee, disallowance on account of cash of 493 and jewelry of so and so is allowed, and additions is not made on total income. Nothing survives. How does it matter that I meet the criteria of 271 AAP? There is no income which has been confirmed. How can penalty survive? There is nothing for the CIT to do.
Let us see, it requires hearing, but I'm saying if it's in the appeal, you raise it in the appeal.
My lord, I have raised in appeal. I have filed 20 submissions. I have raised a grievance. He is not disposing it.
That will direct them to dispose of the appeal expeditiously.
My lord, a time frame, my lord, because this is filed.
Your Lordship, the first appellate Faceless will take up the matters on the basis of three priorities. Not Your Lordship, high pitch demand and remanded cases, time given cases, because if they place request before the authority, my lord, they will consider and
My lord,
take up action.
May take my index, my lord, please.
Okay.
My index for a moment. Serial number 13. If my lords were to see annexure J1, I have filed more than 20 replies. Penalty order was passed prior to the ITAT hearing itself, though I have informed them that the penalty, we have challenged the quantum. In such a scenario, he is not passing an order right from 22. Appeal was filed in 2017.
Yes, they have to.
It is 9 years.
Like early hearing application, they have to file, send or request by mail that it has to be considered at the earliest. That will be considered by the Faceless authority. Appellate, they will take up for hearing, my lord.
Can you not find out that in the chronology, how many more, when it will
Your
be
Lordship, because my lord, the Faceless authority, appellate authority will take up the matters on the basis of, my lord, 3 points.
My lord, I filed in 17. It is a legacy case. All the petitions to be disposed of filed prior to 20. Let my
Your Lordship, I
learned
just
friend answer
made
that.
submission on the basis, my lord, on the 3 points, my lord. Your Lordship may kindly see high pitched demand, early hearing request and remand orders on the basis of these 3 prior.
correct. Nobody is disputing that.
Yes, my
lord. But can you not find out? Yes, it will be taken up in the next 6 months.
Your Lordship, that's what
According to them only, you can get instructions and say, yes, it's there.
I will wait.
Your Lordship, the appellate authority, my lord, will take up the matters for hearing on 3 points, my lord. If it is a cases are related to high pitch assessment, early hearing request or there, or any directions from the court, on the basis of this, they will give priority and take up the matters. In this case, my lord, let them file a request to the authority, my lord, to take up the matter. They will consider that request and pass orders.
My lords may take.
Your Lordship, it is not that or year-wise on oldest comes that year-wise that that is not there before the Faceless authority.
What has happened to 9924 column 17? Column 17.
My lord, column 15, my lords.
17. What happened to the response to the grievance? Page 5.
Nothing has happened, my lord.
Nothing.
Page 183. I have raised a grievance also.
That now you find out now.
Your Lordship, if they have
I
already
raised it to CP Grams, which goes to the Prime Minister's office.
if they have already placed the request,
24. In 24.
Your Lordship, if that is so, if already they have placed the grievance, not your Lordship can consider that and give direction to dispose of the appeal within 3 months, my lord. If there is already a request, not your Lordship can consider that.
There is a request at
Annexure L, my lords.
Annexure L. Just
I have enclosed every single submission that I have made.
The petitioner. Yes. Called in question. The sought for setting aside of the penalty order under section 271 capital A B of the Act dated 11/10/2017. Passed by respondent number 2 for the assessment year 2015-16 at annexure A. The petitioner has also sought for issuance of writ of Mandamus to direct respondent number 4 to adjudicate and decide the penalty appeal for the assessment year 2015-16 within 3 months. Full stop. Legal counsel for the petitioner has raised various contentions, including that the additions have been, proposed additions have been given up in the order giving effect to.
Annexure H, my lords.
At annexure H.
Para 9.
And accordingly, the question of imposing penalty does not arise. Full stop. However, it is noticed that an appeal against the order of penalty is still pending before respondent number.
It's 2, my lords.
Before?
My lords. 4, my lords. 4, my lords. Respondent 4.
Before respondent number 4. Full stop. Petitioner submits that he has made several representations and raised grievances regarding not deciding the penalty appeal. The reliance is placed on the representation at annexure L.
Please.
Taking note that the appeal is pending, though not decided, and also repeated representations of the petitioner to be appropriate for respondent number 4 to dispose of the appeal by the petitioner. Appeal by the petitioner.
Dated 13/11, my lords. Annexure E. 13/11/17.
Dated
13/11/17.
Where do you get that?
My lords, annexure E, my lords, index.
Dated
Just point out, my lords. Page 84. My lords may see the right hand top corner, my lords. The last 6 digits is the date, acknowledgement number.
Dated 13/11/17.
Yes.
Copy of the acknowledgement of which is produced at annexure E within a period of 3 months from date of receipt of certified copy of the order. All contentions are kept open. Yes.
Obliged.
15. Kalesh R.
Yes. Yes, income tax.
My lord, in respect of the assessment year 2016 and 17, 148A proceedings has been initiated, my lord. My lord, being aggrieved from that, my lord, appeal has been filed before the first justice court. My lord, appeal filed on 29/2/2024 annexure C. My lord, as per the assessment order, my lord, section AC undisclosed income has been added, my lord. To provide that along with the document that is long-term deposit not taken as authority as a short-term income.
No, now you have paid the deposit for stay, is it? Have you paid the deposit for stay?
My lord, the liability is not existed, my lord. Therefore, my lord, if the appeal is disposed of, my lord, I get the benefit, my lord. Therefore,
Correct, but then you'll have to wait.
my lord,
Yes, Sanmati.
Lordship, if they want early hearing, let them file a request before the authority, my lord.
that time bond and fixing the time, my
So
lord.
we can't take any appeal out of turn. They have got some chronology. It has to go according to that. I'll reserve you liberty to file an application for early hearing. Same would be considered by the authority.
That is, my lord, by that time, my lord.
Out of turn, we can't. There are many people like you. The previous matter also, there was some same thing. Every matter, we can't tell them you finish.
As early as possible, my lord. Within 6 months, my lord, I paid 3 months, my lord.
I
6
won't
months,
give,
my lord,
that's up
time
to
bond.
you. What?
No, my lord, it's not. Your lordship, this is 2025 matter, my lord.
My lord, matter pertaining 2016 and 17, my lord. 148 proceeding initiated in 2023, my lord. After lapse of, my lord, 6 years.
We can't give any direction
7
like
years,
that. They have got some.
I have all document to
No, that may be
demonstrate,
so.
my lord.
It's not a
Before,
question
my
of,
lord, there is no any tax liability.
no, it's not a question of your difficulty. They have to go according to chronology. They can't take it out of turn. We file one application for early hearing. We'll ask them to take note of the same appropriately as per their procedure.
My lord, with that direction, maybe the authority may be directed to not to initiate.
That I can't say. That I don't know the merits of the matter. Otherwise, you pay the minimum
20%, my lord.
20%, it will stand stayed.
Earlier,
Huh?
early hearing.
The petitioner has sought for. Why can't you put it on the on your website?
Yes, my lord.
Suppose this year
Yes, my lord.
you are taking up appeals of 23.
Yes, my lord.
Just to
Your
ensure.
lordship, it is not on basis of years, my lord. It
No,
is,
no, apart from those three directions.
Yes, my lord.
Saying there are three directions, it may be taken up out
Yes,
of
ma'am.
turn. Otherwise, you can say generally.
Guidelines will set out.
So that if it's put on the website,
Yes,
people will know roughly, this is my
Please,
waiting period. The petitioner has sought for issuance of a writ in the nature of Mandamus to direct respondent number 1 to consider and dispose of petitioner's appeal filed against the assessment order dated 1/2/2024 for the assessment year 2016-17 expeditiously in a time-bound manner, preferably within a period of 3 months. Counsel appearing for the department, EI Sanmati, would submit that the appeals are taken up chronologically, subject, however, to cases where there are certain directions from the court, comma, where there are high-pitched demands.
High-pitched demands and remand cases.
And remand cases.
Yes, ma'am.
Full stop. Accordingly, it is submitted that no appeal could be taken up out of turn and the court may not pass such orders. Full stop. However, it's submitted that if the petitioner has any peculiar grievance, the petitioner may be reserved liberty to file application for early hearing. Next.
Application or request.
Or request for early hearing. Next. In light of the stand taken by the respondent, the petition is disposed of, reserving liberty to the petitioner to file application for early hearing / request, which may be considered by the department and appropriate orders passed. Yes, Sanmati accepts notice of the respondent. Accordingly, petition is disposed of. Yes.
16, Nanda Kishore.
So petition is there's a matter concerning the acquisition for the peripheral ring road.
1, 2.
Peripheral ring road number 1.
1.
The Lordships had heard similar matters, my lords, connected it by granting in stay of dispossession. Copy has been served to Mr. Murugesh V. Charati.
Counsel Shri Murugesh Charati is directed to accept notice for the respondents 2 and 3, AGA for first response. Submitted that in the case of similar legal challenge by landowners in WP 2466 of 2026, this court has passed an interim order and an identical interim order may be passed in the present matter also on ground of parity. Interim order dated 2/2/2026 in WP 2466 of 2026 reads as follows. Next. Accordingly, there would be a direction to the respondent BDA not to interfere with the position of the petitioner. Full stop. However, such order is open for modification upon any further development at the instance of necessary application by the respondent. All full stop. List along with WP number so and so.
17, Ramurthy R.
My lords, item number 87 also similar order may be passed.
87. Same, identical.
Identical order.
87.
The office objection is there with regards to list 2, my lords. List 2, item number 87. Order is list.
So same order in 87. What is the office objection?
My lords, full copy of the annexures of preliminary notification, final notification, it may be overruled.
That is the only office objection.
That one, my lords, and copy has not been served to AGA, but we have been served and the seal is there on the. An age proof is there, my lord, that we furnish the Aadhaar card.
Office objections are kept in abeyance for the present 87, same order.
Great.
17, Ramurthy R.
Pray for a short accommodation may be taken up next week.
Request relist on
25th.
Yes.
18.
I'll accept notice, it's against an order passed by the first appellate authority
Which one? It's for
Previous.
17. And Council M. Kumar accepts notice.
It's against an order passed by the first appellate authority, my lords. Matter has to be entertained here since the tribunal is not constituted. So far as stay is concerned, my lords, matter pertains to 16(2)(c) on merit. Since 10% has been deposited before the first appellate authority while filing an appeal, stay could be.
Madhavan Pillai accepts notice of first respondent. AJ for respondents 2 to
Respondent 2 to 5.
2 to 5. Petitioner has raised various contentions while also challenging the constitutional validity of 16(2)(c). Taking note that
Not challenge the validity as such,
Huh?
but that provision has been invoked.
no, but you look at
They said read down prayer number 43, my lords.
42, you see.
Please, my lords. I'm sorry, I didn't look at it.
Now this is before the apex court, is it?
Yes, no, my lords, it's pending here.
Here.
There are judgments of various high courts for and against.
Division bench, is it?
No, my lords, I think one of Madras High Court.
No,
High
no,
Court has
here.
read down.
Here.
Here it's still pending before my lords.
What? Then we can take up some matter.
It can be taken up, my lords, subject to the central authorities filing their version with regard to the validity of the provision.
In Bardidira. Of the CGST/SGST Act. It is submitted that the identical issue is under consideration in other writ petitions as well. In light of the same, matter requires consideration. In the interregnum, there would be stay of
Annexure
All
A and
further
B.
recovery proceedings pursuant to Annexure C, my lords.
stay of annexure A.
Annexure A is appellate order, my lord.
Annexure A has now merged with Annexure C, which is an appeal order.
Annexure C and proceedings pursuant thereto. Yes.
18, Krishna Rao.
ಬೇರೆ Madhavan Pillai for.
But respondent number 2 is a formal party in this.
Just 1 minute, just 1 minute. Madhavan Pillai for 1, 2, 3, 4, 5.
Appearing for the petitioner, my lord.
Yes.
My lord, one show cause notice for 2 assessment years, my lord. It's at Annexure D, page number 25.
Consolidated order.
The Pramur is causing lot of problems. Huh? Huh. So which is the time period? 18 to 20.
18 to 20, my lord.
18, 19 and 20.
Anyway, page 26, tax period.
25, sir, Annexure D.
ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಬಿಡಿ ನೀವು ಕಾಪಿ ಕೊಡಿದ್ರೆ ಅವ್ರು ನನ್ನ ಕಾಪಿ ಕಿತ್ಕೊಂಡು ಓದ್ತಾರೋ
My lord, you've been asked to file online and
No, for the central government, they can't.
No,
take it
online.
out.
Online your file, is it?
Yes, my
State
lord.
we can do it somehow.
We'll serve it, my lord. Just take it.
So many files pending to be served.
No, at least by email you must serve, isn't it?
Yes, my lord.
So that then also they will get digitally, they are also ready to.
Email or by WhatsApp if they send, Malaj. We'll download it into our.
Digitally they'll argue.
They also want electronic.
The petitioner.
We require for our reference one.
Correct. Petitioner has called in question the validity of the proceedings and points out that single show cause notice is issued for multiple tax periods spanning between 2018 to 2020. In light of the order passed in Pramod Homes and Shelters, This is so and so. There would be stay of
Annexure K and L, my lord.
annexure K and L. Learned council G1 accepts G1 even accepts notice for respondent one entry, AGA for the second respondent.
Much
Yes.
obliged.
19 Prakash D. 19 Prakash.
Your Lordship, here the challenge is to the show cause notice at Annexure F, Your Lordship, where in response to 142 notice, the petitioner has replied with all the supporting documents, and that document has not been considered by the authority. Though it has been considered, it has not been accepted by the authority, saying that the certificate issued by the authority is not the proper officer who has issued the distance certificate. So that is the question raised in the petition, Your Lordship. So there is no mandatory that the distance certificate has to be issued by the Tahsildar. So the relevant page is at page 52, Your Lordship, 52, the petition. Page 52. The distance certificate is extracted in the show cause notice itself. So this has been issued by the PWD officer.
What is this? It should be away from?
Pardon?
The land should be away from?
8 kilometers from the municipality, Lordship. It is more than 16 kilometers. So it is exempt from the levy.
If it is beyond only, then there is a.
Yes, Your Lordship, yes.
Exemption.
Here the officer says it is beyond 16.10 kilometers away from the Sakleshpura town municipality.
There is an exemption, is it?
Yes, Your Lordship. But notice doesn't consider that. It only says it is not acceptable. Only on that, this thing, the demand has been confirmed.
Yes.
Whether it has to be issued by the revenue authority. Well, his submission is that the PWD authority, the assessing officer's observation, PWD, instead of PWD, you get it from the revenue authority.
No, he has got from PWD.
PWD. So maybe they are right in saying that revenue get a similar certificate from the revenue authority. That is all.
No. It could be kept in abeyance. You give it from the revenue department.
Pardon me?
Yes, Your Lordship.
No, what's it now? They're saying you get it from the revenue department.
Yes.
There are decisions where the authority issue, where the certificate issued by PWD has been accepted by the department, Your Lordship.
Now, where is the stipulation now? Is there any stipulation?
It is under the definition, Your Lordship. It is in the definition.
No. The authority to certify.
There is no such mandatory there is no such mandatory, Your Lordship. In some cases, the certificate issued by PWD has been accepted. In some cases, both the authorities have issued. So department blindly says that the certificate here issued by the PWD, therefore it is not acceptable. That is the only this thing. So the department can further, if there are if they wanted any further clarification, they can get it ascertained from the concerned officer, Your Lordship. Because since from 142 notice, I have replied to all the notice. If my lords could see in the synopsis, even in the show cause notice, I have responded to all the notices and with supporting documents.
Order is not yet passed. You are
not yet passed.
No. Even the order will be the same because in 142 the notice I have filed the reply, Your Lordship.
No, meanwhile you get one from the revenue department.
Same thing you get from, let us wait for that and then afterwards we'll dispose the matter.
You might as well get something from the revenue department also, except for some small inconvenience. It would help your case. I'll adjourn it, you find out.
Yes, sir.
Is there any time barring you there?
No, nothing. It is in time. No.
The council Tirumalesh accepts notice for the respondent. Just week after next. Now, if you want to get out of this litigation,
yes,
might as well get something and give it to him. There ends the matter. Let us. Yes.
20. Pradeep. Raviraj.
I
hearing has not been given in spite of request.
Lord, whether hearing was sought is the only issue. If they're sought.
And also he has relied on some material which has not been supplied to me.
No, have you sought for?
Because the
personal-
section says,
Yes.
my lord, hearing.
Page 88, my lord.
Page?
88.
Page 89. He notes VC adjournment, medical grounds, and does not give the adjournment, nor does he fix on the day which originally designated also. In the order, he says no adjournment request was made.
So there was no date assigned after this.
No date assigned.
Where is the order?
Order, my lord. Page number 21.
Yes. Which paragraph?
Page 45, lordship. May. In page 45, the para starting from further. He says not requested for further adjournment.
So before 24th, you have made a request.
Yes.
On 23rd.
On 23rd. And I requested only for 2 days, 26th.
Yes. The petitioner has sought for setting aside of the assessment order passed under section 143, subclass 3 read with section 144, capital B, at annexure A, passed by the respondent for the assessment year 2024-25. Is the case without the stand of the petitioner conclusively submitted that though SSC had made out a response to notices and reply at the time of hearing of the matter, petitioner had requested for personal hearing. It is admitted that though the matter was set out on 24/12/2025 at 3:30 p.m. due to certain medical reasons, the petitioner had made out a request for adjournment in terms of the request as reflected at annexure D. It submitted that no order had been passed of adjourning the matter and assigning a fresh date. And accordingly, petitioner was waiting for some response. In the interregnum, the order is passed. Peruse the order. It is noticed that the authority has taken the stand that SSC did not appear for video conferencing on the scheduled date and time and proceeded further to conclude the proceedings on the basis of the material available on record. Counsel Shri Raviraj submits that request made at annexure D is a part of record and court may pass appropriate orders. Next. Taking note that the request that the date of personal hearing through VC was fixed on 24/12/2025 and request was made on 23/12/2025 citing medical grounds. The authority ought to have passed an order of either adjourning the matter or rejecting such motion of adjournment. Full stop. In the present case, though.
The observation is, my lord, he has not sought for adjournment, that itself.
No, but it says medical grounds.
No. My lord, page number 45.
40.
SSC has
Settlement
not
request can
requested
be
for
found in
further
page 8.
adjournment. That goes against the fact of.
Yes. Full stop. In light of the annexure D, the petitioner has made a motion of adjournment before the date fixed for hearing. The same, however, has not been taken note of, and there is no reference to such motion of adjournment. Accordingly, the order at annexure A is set aside. Matter is remitted at the stage of personal hearing.
Yes, my lord, there are two grievances. He has also relied on a lot of material which is found in the assessment order, which is not furnished. So when he makes the fresh order, the same may be given and an opportunity of rebuttal may be provided.
That you make
No,
a
that is
request.
always there, my lord, once this
That
order.
you make a request.
And secondly, my lord, he has
Let him
also.
make a request, my lord, as per 144, 6, 7, my lord.
Second opportunity.
144B, my lord, 6, 7. One 144B, my lord. Clause 6. Clause 6. Then, my lord, there 7 again down.
Fresh order may be passed after considering.
Let him make a request.
No, if he has got the material, he has to give it to me. What request can I make?
No,
Unless I know
personal
what
hearing.
material he has.
144.
6. There, my lord, down there 7, Roman 7. Subclause. In a case where a variation is proposed, just down there, my lord.
144, 6.
B, 144B, capital B, 6. For the purpose of faceless assessment. 6.
Yes.
There, my lord, down there, my lord.
Yes.
7 only. The SSC or his authorized representative, as the case may be, may request for personal hearing. You know, later part of that 7. Let them make a request, my lord, it has to be granted.
Yes.
Then 8, where the request for personal hearing has been received.
Yes.
This order will go, my lord, because adjournment, this one has not been considered.
Correct. So then now he has to make a fresh request.
He has to make a request, it has to be, and he has to be heard.
I have to be heard and you must supply all the material in his position.
The matter is remitted, full stop, to the stage of personal hearing.
To the stage of notice of variation. Shoka's notice for variation.
My lord, 144B6, my lordship.
That is a variation.
144B6.
To the stage of notice for variation.
The petitioner is entitled to make request for personal hearing, which may be considered. Full stop. Petitioner further submits that the petitioner needs to be furnished with the documents that is relied upon by the revenue.
Particularly in para 4.
As referred to at para 4. Para 4, full stop. Needless to state, it's open for the petitioner to make appropriate request regarding the same, which the authority may consider as per law and
also
all contentions are kept open.
And also uninfluenced by certain adverse inferences drawn in the assessment order.
So that I can't say now.
No, let him consider afresh.
No, we have now remanded it back. All contentions are kept open. Yes.
Only because he has said no loss can be allowed. I don't want him to be bound by his own if an observation can be made,
While proceeding further, the authority may take an independent view of the matter.
yes, much obliged.
My lords, I appear for the petitioner, my lords. It is a, my lords,
Yes.
it is a challenge for order passed under section 73(9) for a period where the turnover is from the VAT, which has not been considered by the authority. At page number 55, my lords, the reasoning of the orders.
First time, is it? You want to have a look at it?
They have filed an appeal before the first appellate authority challenging the adjudication order.
Just use the mic.
That's against the adjudication order, my lords, they have filed an appeal before the first appellate authority. And the first appellate authority has dismissed the appeal on the ground that it is barred by limitation. However, my lords, they say that against the order in original, they had filed an application for rectification and an endorsement was issued rejecting their application for rectification, and they filed an appeal against that. If they give the dates, my lords, I can see whether the matters go back to the first appellate authority to be decided on merits.
You just furnish necessary information to Hem Kumar. He'll just relist. AG Hem Kumar accepts notice for the
For both the respondents.
For the respondents, relist the matter, same stage on
25th.
Yes.
Grateful, my lords.
22, Ravi Shankar is.
Looks for the petitioner, my lords. This is read challenging the order and original pass, my lords. One of the issue is the consolidated show cause notice, which my lords can find it in page numbers 57 and 58, my lords. From the request, my lords, attention. Table, my lords, bottom, July 2017, and over the leaf, my lords, December 2019.
The Council Arvind Chavan accepts notice for the respondents. In light of the submission that the show cause notice relates to different tax periods spanning from July 2017 to December 2019. There would be stay of
Annexure A1, A2, my lords.
Annexure A1 and
A2, my lords.
A2. Taking note of the order passed in Ramur Home and Shelters versus.
My lords orders also annexed in page number.
Let us see.
Annexure C, my lords.
Let us. Yes.
Obliged, my lords. Great.
Santosh Sagar.
Lordship, petitioner is a public sector undertaking owned by the government of India. Challenge is to the order passed under section 73 on two grounds primarily. The grounds mentioned in the show cause notice are different from the grounds considered while passing the order in violation of section 75(7). And the time limit between the issuance of show cause notice and the date of the order is less than the mandatory period of 3 months as specified under section 73(2). So on the time limit of 3 months, Lordship, the Honorable Delhi High Court and the Bombay High Court have taken a view that 3 months specified in section 73(2) is mandatory and the time limit cannot be reduced. So in the instant case, the time period between the show cause notice and the date of the order is less than 3 months, Lordship. If I may be permitted to pass on the. Lordship, in the decision of the Delhi High Court, Lordship may pursue para 9, where the operative portion starts, Lordship. And in para 10, and in page number 5, Lordship, may I read? The internal para 23, Lordship, 22. In the opinion of the court, there is a difference in the language of the two subsections discussed here and above. Section 73(10) of the CGST Act prescribes an outer limit for passing of an adjudication order under the Act. On the other hand, Section 73(2) of the CGST Act provides that at least 3 months prior to the outer limit of 3 years for passing an order under Section 73(10) of the CGST Act, a notice is to be served. While the purpose behind Section 73(10) of the CGST Act is to fix the date by which an adjudication order has to be issued, the purpose of Section 73(2) of the CGST Act is to ensure that at least 3 months is available to the taxable person for filing a reply to the show cause notice issued to them and for being heard in a proper manner. Thus, the time period between issuance of the show cause notice and the outer limit for passing of the order should be at least 3 months. The
So here, in your case,
yeah, in this case, Lordship, the time limit is less than 3 months.
what is the dates?
The show cause notice, Lordship, was issued on 26th of September 2025. Thereafter, submissions were filed on 23rd October 2025. Only one personal hearing was conducted. No further questions were sought by the respondent. An order came to be passed on 17th December 2025.
Let us see. It's a matter of prejudice, whether caused, etc.
They have, it is not that they have not been given an opportunity to file their reply. They have filed a detailed reply, and which has been considered in detail. Personal hearing has been granted, and a detailed order has well considered order has been passed. The outer limit is for passing of an order. It is not that we should for every time we should pass an order after 3 months.
That by itself, in the absence of any prejudice.
Yeah, we will not vitiate the order, Malaj, because I can understand if we have not given them an opportunity of hearing or given them an opportunity to file a reply to the show cause notice. Reply has been filed, that has been considered, personal hearing has been granted, they have been heard, and it's a well considered order, Malaj, and it's an appealable order.
What is the other contention?
Lordship may pursue page 45 for a moment in my writ petition. In page 45, I have attempted to tabulate, Lordship, what is the ground given in the show cause notice and what is the conclusion drawn in the impugned order and what is the prejudice caused. The grounds given in the show cause order or notice are completely different from the basis on which the order is passed. It is on this basis the averment is being made, Lordship, that 3 months is mandatory. If further information was required, any further clarification was required, nothing prevented the respondent from issuing another show cause notice or putting me to notice on the new grounds that were considered in the impugned order.
You find out.
Please.
If at all he say that the grounds made in the show cause notice and the conclusion in the order are at variance.
Maybe the language that is employed is a little different, but it's settled law that the adjudicating authority cannot go beyond the proposals made in the show cause notice. So he would have considered that knowledge, and this can be considered by an appellate authority also. It is only to escape from the liability of depositing of 10% of pre-deposit. Writ petitions are being filed.
Lordship, each of
all
these
factual positions. My lords may kindly see. I'll go to page 45 itself. There is no ground of violation of principles of financial justice. If certain replies that is filed by them is not properly considered, then that the appellate authority can consider it. He is only an extension of the adjudicating authority.
And so far as this table, you have a look at it. If at all there is some ground in this SCN and
Please.
the order passed, if at all that's the only ground appears to be available to him, I'll have it next week. PG N. Kumar accepts notice for the respondents. Relist in the same stage on. This is a PSU, is it?
Yes, Lordship. Central government PSU, Lordship.
So it's a distant cousin.
Please know that?
Distant cousin, because central government. Tuesday.
Lordship may grant an interim order.
Tuesday will consider. Yes.
Lordship may take it up on Wednesday, if not.
Wednesday, in the same stage.
25th.
Much obliged.
24, Madhusudan.
Yes.
Please, Your Lordship. This is basically a order. This for the assessment year 2021. The petition before Your Lordship is a practicing advocate in arbitration matters and international mediation. He was working for the government of India on a Keynes arbitration, and in the course of arbitration for international, he was bound to pay foreign lawyers and others some amount. So he entered into an arrangement with the government of India that they will be passed through his accounts. He was collecting it from the government and passing on to the appropriate lawyers across the world, either in Paris, US, wherever it was happening. Now, this matter was examined at the time of original assessment in detail, which your lordship will get it at page number. Page 36, annexure B. Page number 109, my lord. Original 15/11/21. The question was asked. All these answers were given, and an assessment order came to be passed, accepting my explanation that it is only reimbursement and not liable for tax. Page 109, my lord. Notice and reply is at 112. This was the queries regarding all the payments were asked for, and the entire detailed reply your lordship will get it at page 112 onwards. Nature of the outward, first at annex, I do not want to labor much, my lord. Note on the nature of outward remittance and reason for non-applicability of withholding taxes. Explanation was given, and noting that explanation, an assessment order under 143 came to be passed, annexure B, page 36. There's nothing much explanation there, but then 142 one notice was given, explanation given, my returned income accepted. Now what happened? Well, after this, the commissioner issues a notice under 263 and saying no, that payment should be claimed as expense. We are not claimed as an expense at all. The commissioner says it ought to have been claimed as expenses and issues a 263 and passes an order. On 263, I have already filed an appeal before the tribunal, statutory appeal, and the appeal is pending. In the meanwhile, order giving effect to 263, notices have been issued, which is at annexure A and A1, which I am now impugning before your lordship because the tribunal does not have the power to stay the assessment. Recovery's power is imposed. So now the point, my lord, is when the matter whether the revision is correct or wrong is pending before the tribunal. So I seek your lordship to stay further proceedings. Similar matter, my lordship, this court was pleased to consider and stay the proceedings, my lord. Same. I've given all the papers to my others. Basically, the consequential proceedings so that there is no.
Yes.
Your lordship, because of it is a time-bound proceeding, but he has to issue notice, but he has to act upon the directions issued by the commissioner under section 263. That is why I'm seeking the stay, my lord. My friend is right in saying that is time-bound.
So till the revision is decided.
Yes, my lord.
They're seeking for interim. The Lord Senior Counsel appearing for the petitioner has called in question the validity of the notice under 142(1) of the Income Tax Act. It is submitted that proceedings are pending under section 263 initiated by respondent number 2.
The proceedings are pending before the tribunal, my lord.
Huh?
Proceedings are pending in the tribunal.
Correct.
Validity of 263 order. Challenging the validity of 263.
The validity of the proceedings under 263 are pending consideration before the tribunal.
Yes, my lord.
In light of the same, there would be stay of operation of notice.
Stay as prayed for, my lord, because the two notices are there.
A1 as well as the operation of the corrigendum notice at annexure A2 and consequential proceedings pursuant to A1 and A2.
Yes, my lord. Otherwise, they'll issue one more notice, and it's protecting them, my lord.
Sanmati accepts notice for respondent 1 and 2. Pray for is always dangerous because nobody applies their mind. Neither the judge applies his mind nor the steno applies their mind.
25, simulation.
Yes. Yes.
The consequent annexure in my petition, my lord, para C at page 27, I have sought for
proceedings, including
consequent proceeding as per annexure D, my lord.
D.
Obliged.
25, Tirumalesh.
GST on royalty has to be stayed.
The petitioner submits that the identical question
Who are the
regarding levy
respondents?
of GST on royalty
Respondents.
is pending before
Copies
the
are not
apex
served
court.
earlier.
The order is there.
In the
Apex
age,
court and
served
so
it
on.
on age.
Light of the same, there would be stay of GST on royalty insofar as demand at annexure.
Lecture A, B, and C.
A, B, and C.
Yes.
Yes, Learned Counsel N. Kumar
serve ಮಾಡಿ
accepts notice for the respondents. Yes.
Yes, submit.
One copy to be served.
Copy. Yes.
My lord, the service tax matter, where an
Yes.
order has been passed for 16, 17, 17, 18 based on the income tax return, my lord,
Yes.
covered by Chinmaya Seva Trust.
Yes, yes.
Matter may kindly be remanded.
Notice, my lord, if I have it next Tuesday.
Learned Counsel Arvind Chavan accepts notice for respondents.
One
All the
and
respondents.
Deputy
For the
Assistant.
respondents. This is the
One and-
matter. The same stage
Next Tuesday.
on Tuesday.
25th. 27, Ravi Shankar S3.
This is a petition for assessment year 17-18.
Yes.
Notes may take to page 59 minutes. In page 59. Notes may assessment year is 17-18. My lords may see the date 17/4/24, adjacent to the year.
17.
April 2024. It is barred by limitation.
What is the time period?
6 years, my lords. So
From
by
the end of
31st
the-
March 24, it should have
From
been
the
issued.
end of the assessment year.
Yes, yes, my lords.
So 6 years will end on
31st March 24.
151/6.
151, for reopening it is 6 years.
No, 151 subclause, what?
Two, my lords,
2.
please.
Yes,
My lord may see 149, my lords.
149.
That's the time limit for initiation of.
But no, so we'll stay it, let us see. You take this.
Please.
We'll stay it, let us see.
Yes, yes, yes.
Annexures A to
Counsel for
A6,
the
my lords.
petitioner submits that the approval itself, is it?
Please, my lords.
Approval under 151 is passed on 17/4/24, which is beyond the period of 6 years from the end of the assessment year in terms of section 149.
Please, my lords.
Accordingly, in light of the contention raised, there will be stay of
Annexures A to A6, my lords.
annexure A to
A6.
A6. Learned Counsel Sri Tirumalesh accepts notice for the respondents 1, 2, 3.
Please. Obliged.
8, Venkatesh G. 8, Venkatesh G.
Yes.
Please, your lordship. This is a case of remand, my lord. My request, your lordship, is that less than 7 days has been given. Your lordship judgment is placed at page 125. And as far as the addition is concerned, of course, there has been an error on the part of the SSC also that what had happened, my lord, is an SC for the last 30 years. He has a capital of about 25 crores. But unfortunately, in the earlier years return, the computer technology has taken balance sheet all as 0. And this year it has shown the correct balance of 25 crores. So the officer has simply added the entire capital earned by me for the last 50 years as income of this year. Maybe we are not explained, my lord. If it goes back, we'll be able to explain, because I placed before your lordship all the balance sheet right from 2013, which your lordship will get it from page 132 onwards. How I have grown every year, I have offered income. And if your lordship were to see page 34, the income declared by me and paid taxes for all the years is also tabulated. On the short point of that less than 7 days, your lordship may consider remanding it back, so that we'll be able to explain, my lord.
Where is that notice?
Notice is at page number 98, my lord. And at 100 is the date given. Notice is dated 12/2, and time given is 18/2.
Where is the date for response?
At page 100, my lord. Para 3, 18, 6 days, my lord. Last, from the below, para 3, at 10:23 hours on so and so.
Yes. Can we send it back? You want to have a look at it? Or?
Yeah, Lordship will see page 77. It is not as though they complied with earlier notices. None of the notices they have replied.
Anyhow, the last of the notices.
Yes.
Shall we say?
Some of the notices they have given 1 day's time. Some of the notices they have given 15 days time. But that is 274.
Statutory notice is show cause notice.
Yes.
So
At page 65.
So we'll send it back.
Yes.
The petitioner has called in question validity of the assessment order under section 143 subclass 3 read with section 144 capital B of the Income Tax Act. Passed for the assessment year 2022-23 at annexure A1 and has also sought for setting aside of the computation sheet at annexure A2. The demand notice at A3, penalty order at B1, computation sheet at B2, demand notice at B3, penalty order at C1, computation sheet at C2, demand notice at C3, and order of rejection under 154 of the Act at annexure D. Apart from raising various other contentions, it is pointed out that the matter requires to be remitted for reconsideration as the show cause notice dated 12/2/2024 was directed to be replied by response by 18/2/2024. It's submitted that such time limit of less than 7 days amounts to a violation of principles of natural justice and is also.
It may also be mentioned that they have not replied to all notices because the Lordship will get at page 65.
And also in violation of the SOP applicable for faceless assessment. The reliance is placed on the order in WP 12923 of 2023. Next. Land Counsel Shri Tirumalesh appearing for the revenue submits that while the petitioner has sought to assail the last of the show cause notices. However, even earlier in the earlier proceedings, petitioner has not demonstrated due diligence. Next, heard both sides. At the outset, it must be noticed that as rightly pointed out by learned senior counsel appearing for the petitioner, notice at annexure F is dated 12/2/24 and the time made out for response is 6 days. Full stop. This court in WP 12923 of 2023 has made certain observations in an identical factual matrix and the observations at para 2, 2 and 3, 2 to 6, 2 to 5 reads as follows. Next, in light of the violation of the applicable SOP at clause N.1.3, the proceedings required to be reopened. Though learned counsel for the revenue submits that the petitioner has not been diligent in participating in the previous proceedings. However, the question to be looked into is the show cause notice at annexure F, which is in issue, irrespective of the previous proceedings. If the illegality is found in the time limit prescribed at annexure F, the said show cause notice is required to be set aside and matter remitted with fresh opportunity to the petitioner. Accordingly,
A series, B series, C and D, my lord.
the orders at annexure A series, B series,
C series and D.
Are set aside and matter is remitted to.
I would request Lordship to send it to the jurisdictional officer, subject to what my friend has to say. Respondent 2, my lord. So you can actually explain the.
If they have a procedure of sending it to the faceless, and if it is sent to the jurisdictional.
Lordship may send it to respondent 2.
Matter may be remitted to respondent number 2.
2, my lord. The jurisdictional officer, JAO.
Respondent number 2, what is the stage now?
At the stage of reply to show cause notice.
To the stage of reply to show cause notice.
We'll reply in detail, my lord.
Petitioner to be present without further notice on
whatever date, Lordship.
16th of March.
Lordship.
Accordingly, petition is disposed of, learned from the preliminary checks and notice from the respondent.
29, Ashok Kulkarni. 29.
Yes.
Here the assessment is made on a non-existent person. I'll briefly set out the fact, my lord. Here the family consisted of husband and wife. That was the HUF. The husband passed away. As a result, the family extinguished. This was brought to the notice of the assessing officer during the assessment proceedings. He extracts whole of my letter and all that. Then one line he disposed of saying that there is no proof. I have produced the death certificate of the Karta, and a member of the family will not constitute HUF. So the assessment itself is ab initio wide, my lord. And in fact, there is no provision under the Income Tax Act to make an assessment on a non-existent HUF. And Lordship are aware that there are a number of decisions when a family consists of only 2 persons, that too a female member,
yes.
A wife is not a co-partner.
Your Lordship, the petitioner is challenging annexure D, my lord, assessment order passed under section 144, read with section 250, read with section 144B. Your Lordship, this order is passed on 17/1/2026. Your Lordship, this order is passed in view of the remand by the Commissioner of Income Tax. Lord, this is order giving effect to the first appellate authority's order. Your Lordship, the opportunity was granted to the assessee. He has uploaded the details. Your Lordship, the case of the assessee is that since the Karta of the family died on in 2017, he could not have continued the proceeding. Your Lordship, may I kindly see the status of the case, the assessee, my lord, GM Muralidhar HUF. It is in the case of HUF. The assessing authority has clearly held that even after his death, the wife continued to be Karta of the family, and she has filed the return, page number 51, my lord, in the highlighted portion. Page number 51, my lord, in the highlighted portion down below. It is also noticed that the return of income for assessment year 2023-24 of the period much later than the year under consideration had been filed on 25/8/2023 by Dakshayani Muralidhar in the capacity of Karta. She continues to be after the husband's death, she is the Karta of the family and she has filed the return. So the HUF continues, my lord, and she has become the Karta.
Okay, now insofar as the legal position,
Lordship,
if there's any authority, you place it.
Yes, my lord. Lordship may post it on day. There are a number of cases.
So,
I will just produce
one more submission. Just prior to that paragraph, Lord, the previous paragraph, during the BC, the learned assessee representative of the assessee spoke of non-applicability of the assessment provisions to the case of the HUF was claimed to be single member HUF. This claim is not acceptable as no supporting proofs are furnished which would substantiate the claim. And further, my lord, in page number 47, in the middle of the page, the assessee, in the middle of the page, my lord, after that highlighted portion, the assessee uploaded some documents without giving any correlation and reasoning in the justification and explanation of their points on the issues of scrutiny, and no supporting evidences has been furnished. There is no proper representation, not proper reply by the assessee.
Correct. Now, they're raising a jurisdictional point. Let us see if there's any authority.
Yes,
they're saying there cannot be a single member HUF.
Yes,
Let's see if there's any authority. We'll see.
Your Lordship, this is appealable order, my lord, all these
Correct,
points. can
but
be
if
heard.
it's, if the position of law is clear, then Godrej Sarali. Let us see. Let them, we'll have it on
Lordship,
Tuesday.
if it is in the case of individual, the legal positions are there. It is a case of HUF. HUF have continued.
Okay, so let's see if they say they have some authority.
We have some authority, my lord.
We'll have it on Tuesday.
A female member can, that the wife cannot be a co-partner.
Correct. If there's any authority directly on the point,
Lordship.
on the legal position, you place it, let us see.
In fact, I have referred to in my writ petition, but I have the decisions. I will place it. Lordship may have it at a very short notice. I will just
Relist the matter in the same stage on Tuesday.
My lord, I have some difficulty 24th and 20th, personal difficulty, my lord. 26th, if it's not too inconvenient, my lord.
26th.
Thursday.
Friday, Friday. 27th.
Lordship, Friday.
This position according to you is clear.
Absolutely, my lord. And there is a decision of this honorable court also, which I have referred. My learned friend must be aware of it.
Your Lordship,
I'll make my submissions.
she herself has filed the return as HUF.
That will not make.
No, that
What
may,
is?
That may not, that may be so. But if it's a legal position that it's impermissible, then it goes, whether they file it or not. That legal position, let's have a look at it.
By consent, I cannot confer a jurisdiction, my lord.
Let us see.
Lordship.
30, Sandeep Purivo, 30.
It can be in the same stage, isn't it?
Please.
Only that question.
Yes,
Seal number 30 is challenging GST proceedings. I think Tuesday.
I'll accept notice for the respondents. my lords.
AGA M. Kumar accepts notice for the respondents.
Lords, with regard to interim order, my lords, an order of confiscation has been passed by the proper officer, which was challenged by way of an appeal before the first appellate authority. First appellate authority has modified the order passed by the proper officer, against which, my lords, suo motu revision has been taken up by the additional commissioner. So since the tribunal is not here, matters will have to be entertained here. And insofar as consideration of interim order is concerned, my lords, I'll have to get some instructions, my lord. My lords may kindly have it on Wednesday, my lords.
I'll just clarify, just add to that, my learned friend, is that I've paid the 20% as required as per section 112. So as against the confiscation order, I filed an appeal, Manoj, before the Joint Commissioner appeals. I had also approached the Honorable High Court seeking release of the goods which were confiscated. Now, in the course of hearing before this Honorable Court, I made an undertaking that I'll pursue my appeal and seek release there also. The Honorable Court directed me to pursue the appeal. I gave a undertaking that I'll give a bank guarantee subject to the outcome of the appeal, which was recorded by this Honorable Court in the order. I gave the bank guarantee, goods came to be released by the respondent number 1. He was satisfied with the value, he's released the goods. The appeal came to be heard, was allowed. Within a few days, Manoj, the matter was taken up for suo motu revision by the additional commissioner. Now, suo motu revision order came to be passed against me, restoring the order of confiscation and reversing the order of the appellate officer. Against that, Manoj, under the GST Act, I have a right of appeal to the tribunal. Now, to maintain that appeal and to ensure that as per 112 subsection 9, I have to pay 20% of the penalty because there's no tax involved. It's only I have to pay 20% of the penalty, which I have duly done. The only limited list before this honorable court is now that I've paid the 20%, which is admitted and acknowledged, can he retain that bank guarantee, which was given, in fact, subject to the outcome of the first appeal? All I'm saying is give me back my BG. I'm going to pursue my appeal before the tribunal. I've paid 20%. Now he is saying, no, kindly see the word which was referred to by the High Court was appeal. When you go to the tribunal, you're going to file an appeal. So therefore, you have to keep the BG pending till the disposal appeal by the tribunal. That is the only point. I'm not going to pursue the matter on merits at all. I have a right of appeal, which I'll pursue. It's a short point. The section requires, I'm sorry.
He wants to check.
Yes, yes.
Only insofar as it relates to bank guarantee, I'll need to get instructions. If they are willing to keep the bank guarantee alive, an order can be given today. But
why should they keep?
I don't.
That's the only point. If the section,
he's asking, not I. But prima facie. So what's your submission?
The section, my lords, is that for me to file an appeal and section 112 may kindly be seen.
No, now revision order you have challenged.
I'm going to challenge because tribunal is not yet constituted. I've paid the 20%.
I will challenge that
Happen very
order before
shortly.
the tribunal.
You challenge it where?
Before the tribunal.
Tribunal.
Now, when I file the appeal before tribunal, section 112, subsection 8
So
mechanism.
you have paid that deposit.
I've paid the 20%. And the section says upon payment of that,
That would stay.
no further proceedings for recovery can be
So
done.
that order of revision will stay.
Will be stayed. I won't even say the order stands stayed. I'll say recovery shall stay because that's what the section says. 112, subsection 8 may kindly be seen. My lords have that?
Yes.
No appeal shall be filed under subsection 1 unless the appellant has paid. A may kindly be disregarded. B, a sum equal to 10% of the remaining amount of tax in dispute in addition to the amount paid under subsection 6 of section 107. This also may not be relevant, Manoj, because it is with respect to tax. The proviso may kindly be seen. May I read?
Yes.
Provided that in the case of any order demanding penalty without involving demand of any tax.
You're reading?
The proviso to section 112, subsection 8. Manoj.
Some amendment, is it?
Yeah, he has the latest.
I can give the
Manoj.
book.
We don't have.
My lords may see.
Amendment agide.
When did that amendment come into use?
2024, sir. 24. Finance Act number 2 of 24.
I have 25.
24 is it? 26.
112 subsection. It's been amended, sir.
Yes.
I'll just read it.
Yes.
112 subsection 8, the proviso to that. It was inserted by way of the Finance Act 25, 110-25.
110. I have to just look into it because the amendment is not there in my.
No, I'll accommodate. I'm just seeing.
Yes, I'll just.
Tuesday or Wednesday I can.
Just to complete, I'll just say. Provided that in the case of any order demanding penalty without involving demand of any tax, no appeal shall be filed against such order unless the sum equal to 10% of the said penalty in addition to the amount payable under the proviso to 1076 has been paid by the appellant. So I had to pay 10% at the time of first appeal, which is section 107, and a further 10% as per this proviso. So adding up to 20% of the penalty, which I have duly done. Subsection 9 may kindly be seen. Where the appellant has paid the amount as per subsection 8, the recovery proceedings for the balance amount shall be deemed to be stayed till the disposal of the appeal. There is no condition in addition to 20% to furnish a BG or to keep a BG which is previously given in subsistence. That is the only point in this writ.
Really unjust enrichment.
Please, that's
They release the matter in the same stage on
Wednesday, Manoj?
Wednesday. M. Kumar accepts notice for the respondent.
31.
Achha.
This is basically for 129 penalties. 130 is an order of confiscation.
31. Alesh R.
Previous matter lay. IA 1 of 26. In serial number 30, IA for dispensation because in from portal.
IA for dispensation, please, Manoj.
Huh?
Yes,
Printouts,
yes, yes.
As printouts have been taken from the documents uploaded on the portal. IA is allowed petitioner dispensary production of certified copy of so and so. IA 1 of 26, same IA 2 of 26.
31. Alesh R.
Relist.
25th. 32. Prashant, 32.
Please, Manoj.
Yes.
Cost title, Manoj, is as page number 15, Assistant Commissioner of Customs. My learned friend is taking notice in that matter. Page 15 is the cost title, Manoj.
Yes.
Challenge, my lords, is to 29 bond enforcement orders at annexures A to A29. Take 2 minutes, my lords. I have an advance authorization license under customs. If you're an entity that has an advance authorization license, what happens, my lords, is the imports that I do are duty free, subject to me exporting the said commodity within a period of 18 months or 24 months, depending on the sector that I operate in. Now, what I do at the time of import, because it is duty free, my lords, is I execute a bond. That bond is attached to either a guarantee or my bank account to protect their interests. In case I don't export within that 18 months or 24 months, whatever be the criteria, they are at liberty to encash that bank guarantee or enforce the bond. My lords may have this small chart that we have prepared. Chart and compilation that I've passed over. My lords may have the chart. The period, my lords, are 2005 onwards until 2011. You have one table from 2005 to 2010 and one more table between 2009 and 2011. So therefore 29 bond enforcement orders are between this 2005 to 2011 period. Law mandates that I require and maintain records even under the Customs Act only for a period of 5 years. Law mandates under Income Tax Act that I maintain records for a period of 10 years. So even if I were to take 2011 as the last financial year, my lords, I'm supposed to ideally have documents till 2021, 2022. Now, in the case where they want to enforce the bond orders,
Records are to be maintained for?
maximum 10 years even under Income Tax Act. Now, in the case they want to enforce bond in all these bonds that have given them, they have to issue a notice, they have to pass, they have to ask me for a hearing, ask me for something known as an EODC, Export Obligation Discharge Certificate, EODC. Whereas, which is to say that I have fulfilled all of the export obligations under each of the advance authorization licenses that I have for each of the bonds. The minute I submit that EODC, etc., that bond lapses by itself because I have completed those obligations. 29 bond enforcement orders they have passed. My lords may have Annexure A for a moment. Just one of those orders.
Annexure
A. One order, I'll just take my lords through.
Page?
Page 69, my lords. 69.
Yes.
Annexure A, my lords. My lords may directly have para 3. My lords have para 3. The importer has executed bond bearing number so and so, dated so and so, for an amount of 27 lakhs. That's all the information that have been given. This is directly an order. There is no show cause notice. They have not asked us for discharge certificates. They don't even give us details of what is the license number that is available with them. They passed 29 of such orders. Now, my lords, after these orders came to me, I went physically and did a verification in their own systems. My lords may have this chart again for a moment. I went physically to their offices. I did a verification. Out of 29, my lords, the first table, FI 2009 to 2011, for 13 bonds, my lords, I have an EODC certificate. I have a redemption letter. I have EODC certificates. If they had asked me for those details, I would have submitted these 13 bonds to 13 EODCs to them. Number one. Table number 2, which is of 13, and table number 3, which is of 2, these 15, they themselves don't have the details with them. When we visited them, and we have an affidavit of the authorized representative who went to their offices, they physically verified. They say we don't have details of any of these 15 details. Now, if they themselves don't have the details of records prior to 2010, 2005 to 2010, we are now in 2026, 16 years. 16 years, and now they come and ask, and they don't even issue a show cause notice. They directly pass these enforcement orders. There is one similar matter, my lords, the coordinate bench, which had directed them they had quashed all of these orders, directed them to give us details of all of those matters, my lords. That, my lords, in the compilation, my lords may have it at page number 151. That entity was of a defense sector. My lords may have page 154 and 155. A perusal of the communication so and so will indicate that the respondent has referred to the alleged bond dated so and so, said to have been executed by the petitioner. However, though the petitioner submitted the reply communication calling for respondent to furnish details, particulars of the said bond, the respondent has not furnished the same so far and has proceeded to pass the impugned bond enforcement order without furnishing the said bond, nor providing any opportunity to the petitioner in this regard, thereby violating principles of natural rights.
Yes, you find out.
Please, I'll file objections.
No.
There's no need for objections, my lord. This can be sent back.
Well, let us
Because
see in
for
case,
13, in any case, we have documents that we can demonstrate with. For the remaining 15, they have to give us the documents. It can be sent back.
let us see, let them take the stand. Could close it here only in case they don't have that information. Let's see, let
Very
them
well.
take the stand.
In that case, my lord, the stay of all these 29 orders will have to be granted.
The
My lords can have it next week only, my lords. I'll just seek instruction. If there is no objection that is required, my lords, lordship may send it back. My lords, at least next Tuesday or Wednesday, my lords.
Land Council Akash Shetty accepts notice for the respondent. Release the matter. Same stage on Tuesday. Tuesday.
You can
Let them,
after 10 days,
Huh?
you lost. Tuesday may not come. 10 days.
So then we'll stay it.
my lord, may
And
stay.
then you file your objections. The council. Jeevan is more realistic and practical.
Because I had appeared in that previous same.
Even otherwise, you know the officials better than him, the petitioner.
Allah, let my learned friend again repeatedly come and seek time. That's what I said.
Petitioner has called in question the
Bond
validity
enforcement
of
orders.
the orders at annexure A, comma, A12, A26, and A27 and A28.
8 and 828.
It's contended that the orders, bond enforcement orders have been passed without notice to the petitioner. Full stop. Petitioner also has enclosed a table and submits that insofar as bond enforcement orders relating to bonds executed between the year 2009 to 11. Petitioner has EODC.
EODC.
Export
Obligation discharge certificate.
Export obligation discharge certificates. And with respect to financial year 2009-11. With respect to financial year 2005-10 and 2020-2021, it is submitted that the bonds relate to a period of more than 10 years. And in this point of time, action as sought to be initiated under the impugned orders is impermissible as having been initiated after undue delay. So, subject to further consideration, there would be an interim order of stay of the orders at annexure A, A1 to A26, comma, A27, A28, 28. The respondents to take their stand in writing within 2 weeks.
Grateful.
Motor vehicle tax matter,
Huh.
then not to seize the vehicle.
Same order.
The similar matter, my lord. And directed to be posted along with connected matter 2045 of 2020.
2045
of 26. I given the copy. Good. Good. Put up.
The
Copy good.
same order. Same order. List along with WP 2045 of 26. Now this is pending before this court.
Yes, ma'am.
What has happened to that batch?
9th, next month 9th it is batch matters.
Yes.
34, Sandeep. 34.
Yes.
34, Manoj, is challenge to income tax proceedings. What's happened, Manoj, is pursuant to reassessment. There are grounds with respect to the reassessment, but I may not have to press that, Manoj, because there seems to be some glaring errors in the subsequent assessment order and the penalty order. I'll just take my lords through the impugned order annexure B, page 42. This is the order passed under 147 pursuant to the 148 notice. My lords may kindly turn to page 51, Manoj. Order starts at 42, page 51 and 52. Manoj, may see at the bottom it says addition of rupees 1.3 crores. Bottom of page 52, Manoj.
Yes.
This is one issue on merits where he says the officer believes that there's an addition required to be made. The following page, he says total addition is 1.3 crores. Now the error, Manoj, starts from page 55 onwards, which is the accompanying computation sheet, because in income tax there'll be an order, there'll be a computation sheet and a demand notice. 3 documents comprise the entire. Now in the computation sheet, Manoj, which is appended to the order, Manoj will see the entire right column is all 0. So there is some computer error. The consequences at page 58, which is the demand notice issued. My lords have that. At the para 1, this is to give you notice that the assessment for so and so year, a sum of rupees 0 is payable. Now this error on its own did not affect me, so I did not file, because ultimately an SSC looks at the demand, it's 0 payable. What happened basis this order, Manoj, is a penalty proceedings were initiated.
Yes.
And a penalty order at annexure E, page 73 was passed.
Yes.
Page 73.
Yes.
This, my lords, is an order under section 271(1)(c), which is a penalty for concealment of income or furnishing inaccurate particulars. It is founded on the assessment order. Now, for the first time, my lords, at page 76, which is at the end of the order, there is a computation of penalty. There's a table at that one, page 76.
Yes.
Serial number 3 in that, my lords, may kindly see. 2 also above that. Total assessed income as per order 1.3 crores. Tax on that, for the first time I come to know that it's rupees 44,99,000. Then he says at the bottom, serial number 6, penalty imposed 44,99,040. To add, sorry, I would say maybe one more error to this, my lords, may just for a moment kindly turn to page 79.
No, the error is?
The error, my lords, is that the penalty can be equal to the tax which has been levied on me. So if there is an error in the order which says 0 rupees tax is payable, penalty being 44 lakhs is unsubstantiated. And just to add to that, Manoj, the demand notice which is issued for the penalty order, page 79. This is to give you notice at para 1, Manoj. The penalty imposed is 89 lakhs at page 79. Whereas the order, the penalty order says 44 lakhs. There is some computer error, obviously. The result of this is that I'm being penalty, I mean, if tax imposed is 0, tax levied is 0, penalty is 89 lakhs. And that is also contrary to the penalty order, which is 44 lakhs. My humble submission may have to go back. I'll file my reply.
Why you did not participate?
To the penalty proceedings, I participated. The assessment order, Manoj, it was put up on the portal at that time. This SSC was not aware. Penalty proceedings, I filed my reply saying, please
set aside annexure A. Huh? So this A, you did not participate.
A onwards, no. Only annexures, the penalty proceedings, I participated.
This is a regular assessment order,
No, pursuant, reassessment order.
reassessment.
First, 148 notice is issued, after that 147 order is passed.
The petitioner has replied to
The 148 notice at annexure A, I have to file my return in response to that.
142 return.
Return under 139 in response to the notice under 148.
Yes.
At page 38.
Yes, the petitioner has called in question correctness of the assessment order passed under 147 read with section 144 read with section 144 capital B of the Income Tax Act. It is submitted that the petitioner could not participate in the proceedings and has not made out reply to the 148 notice or other notices referred to at para 2 of the table. So it submitted that such lapse is due to bona fide reasons, and the authority has passed an order on the basis of best judgment assessment.
Please.
Full stop. It's submitted that the court may take a lenient view of the matter and reopen the proceedings and enable the petitioner to take stand on merits. Full stop. Further pointed out that consequential proceedings may also be set aside. Counsel appearing for the department submits that taking note that the assessment order is an ex parte order, court may pass appropriate orders while asserting that the petitioner is responsible for not participating in the proceedings. Peruse the order at annexure B. It is noticed on a perusal of para 2 of the order that the proceedings have proceeded ex parte. In the sense, there is no stand of the petitioner on merits. Full stop. It's further noticed that certain variations have been proposed and proceedings have culminated in an order. Next. Taking note of the consequences that would visit the petitioner if the order at annexure B is permitted to sustain, it would be appropriate to set aside the order at annexure B and remit the matter to the stage of
filing a return in response to the notice at under 148.
Filing a return to the notice issued under 148 at annexure A.
Please.
All accordingly, the order at annexure
B, C, D, E, man.
B series, C series, D series, and E series.
Please. There's a recovery letter annexure F also, that may kindly.
Are set aside as also the recovery letter at annexure F in light of order of assessment being set aside and matter being remitted. All contentions are kept open.
35, Abhishek K.
Yes, Anmati accepts notice for the respondent. IA1 of 26 is allowed. At same portal, check ಮಾಡಿ ಅವರ IA ನಲ್ಲಿ in light of printout relating to documents upload. Yes.
Lords, the matter is covered by my lords page number 76.
Page?
Page 76, my lords. The notification, my lords, has been quashed for the preliminary notification. The notification is of the year, my lords, 2016-17. The preliminary notification was done, my lords, but final notification was not done. The entire.
Yes. Tomorrow. Lord Counsel TP Vivekananda accepts notice for the respondent. This is the matter in the same stage. 20th. Yes.
36.
Please.
36. Mohan.
My lords, this is an ex parte order passed on, based on the income tax returns of this assessee, who is a
Yes.
foreign national, my lords. The problem here is there is an attachment of all 3 bank accounts of his, and he's not able to operate any of his accounts at this time, my lords. The orders have been passed.
Have you served copy?
Yes, my lords. I have served a hard copy. Hard copy I'll serve.
Yes.
My lords, the assessee is a foreign national who was a partner at Ernst & Young LLP, my lords. The incomes that he has received are remuneration from the partnership as well as share of profits, which are not taxable under service tax. There are this is a settled position, my lords. I'll pass on a compilation of other partners of the same firm, my lords, who have also received such notices. Now he does not reside in India, my lords. He has left the country in 2018. So he has not had an opportunity to receive these notices or answer to them. And impugned orders have been passed in 2021 and 2023. When he is visiting India presently, my lords, all 3 of his bank accounts have been attached, my lords. The attachment notice is Annexure D, E and F, my lords, page 88, on 19th of January this year, my lords, last month. He has only been able to figure out that there is an order of this kind passed because he is not able to make any transactions from his bank account. Thereafter, his tax consultant visits the office and receives a copy, my lords, but this is not a certified copy as well. Therefore, my lords, my interlocutory application for dispensation of these notices and orders as well.
Yes.
My lords, in the interim, my lords,
They would normally send the notice to the whatever is the data given by the assessee.
We'll have it on Tuesday and then we'll see what is to be done.
my lords, the only difficulty here is, my lords, all his bank accounts have been attached, my lords. The demands are about 8 lakhs, 10 lakhs and 10 lakhs, my lords, but they have computed the interest also and penalty, equivalent penalty, my lords. 1 crore and 4 lakhs of demand has been attached against my bank accounts, my lords. I am not able to operate any of my accounts.
But he has to find out. Today the first date has come, isn't it?
At least one of my bank accounts I may be permitted to operate, my lords.
Let him find out. Monday. Relist the matter. Same stage on Monday. Land Counsel Arvind Chavan accepts notice for the respondents. Yes.
37. Ravishankar.
Lords, for the petitioner, my lords, this is a writ challenging the order in original at page number 56 to 65, my lords, where the respondents have invoked the extended period of limitation. Perhaps respondents have relied upon the notification number 9, which is at Annexure B, my lords, and page number 73, which extended the due date till 31st of December 2023. This validity of this notification is pending before the Honorable Apex Court, my lords, and the same is available in page number 103, my lords. I'm seeking a 103, my lords. In page number 103, the subject matter of challenge before the High Court was the legality, validity, and propriety of the notification 13, notification number 9, and 56, my lords.
No interim relief is granted.
No, my lords.
Huh?
No, my, have been extended. There's difference of opinion. They've issued notice, my lords. No stay. There is a requirements of consideration.
Now, what is the interim relief you're seeking?
I'm seeking stay of Annexure A series, my lords. That is the order in original which is being passed. There are certain demands made, my lords, which is available in Annexure A366, which is the summary.
Now, this court has taken any view? No.
No, my lords. Not that I'm aware of, my lords.
seized of the Supreme Court.
The petitioner has called in question the correctness of the order order under 73(9).
73(9), please.
At annexure A2 and consequential
At A3,
orders as well. The contention that orders passed is beyond the permissible period.
Yes, my lords.
And the notification 9 of 2023
At annexure
B extending the period for passing of order is an aspect that is pending consideration before the Apex Court.
At annexure G, my lords.
Apex Court in special leave to appeal 4240/2025. Further submitted that the said notifications have been this have been set aside by some of the high courts.
Some high courts have, Madras High Court has viewed that the entire notification 956 is illegal, my lords, because there was no consideration or consultant from the GST Council. That I have reproduced, my lords, and
it is further submitted that some of the high courts, including the Madras High Court,
in page number 22, my lords, if I'm
has set aside.
Yes, my lords, they have held that it is unconstitutional.
Has set aside the said notifications. In light of this contention surge, matter requires consideration. There would be stay of
annexure A1, A2, and A3, my lords.
Annexure A1, A2, and
A3, my lords.
A3.
Yes, my lords.
Where Council Arvind Chauhan accepts notice for the respondents. Yes.
Deeply obliged, my lords.
38. Veena Hegde.
The from portal.
Yes, ma'am. It's all dispensation.
Portal.
Download everything from
portal.
Next.
Yes.
For the petitioner, petitioner is, my lords, is a procuring, my lord, a business in a procuring areca nuts from the, my lord, rural Karnataka. His goods and conveyance has been, my lord, intercepted by the revenues on 15/1/2026. MO1 and 2 and issue has been issued, my lords, and my lord, MO3 is also issued for extension of time. And my lord, physical verification has been done on a ground that, my lord, at the time of, my lord, interception, the driver did not produce the, my lord, tax invoice and LR receipts. And e-way bill has been generated only after, my lord, 1 hour of the interception. That is only the allegation. And later, my lords, we kindly see, immediately after, my lord, MOE 6/129 detention order has been passed, without following the all procedures as required under the, my lord, law, as, my lord, this honorable court and various high courts have held that 129 is independent proceedings. Entire proceeding has to be followed by the revenue. They have to, my lord, issue, my lord, after detention of the order, my lord, 29(1)(a) and B has to be followed. Without following that directly, my lord, they have confiscated my goods and conveyance under 130. The notice has been issued now, challenging that order, my lord, before this honorable court. One more thing is that, my lord, while issuing 130 MOE, my lord, 10, there, my lord, there is, my lord, they say that the 130 is issued only on a ground that no e-way bill has been generated. If my lordship may kindly see the MOE 10, my lord, page number 1 of the, my lord, page number 101, at paragraph number, my lord, 7.
Yes.
No e-way bill generated at the time of vehicle intercepted. No e-way bill. All 6 conveyance, my lord, the same issue has been raised.
Okay. Now,
Lord.
Then go to 130. Because now that today prayer will only be regard to release of it. Other means kindly turn to page 18. One of the notes. Before that, let's get launch to page 89. Page 89 down below. Access to consignor, consignee, and the transport. All of the non-receipts. And Immediately, all the situations of being transported, goods are being transported, those to only show the contact of practice to the city, not kindly done to page 80. One paragraph, page 79. Not for remote, one thirty. Compensation of the rules and damages are so on, 130, 131, 4. Consignor has not generated the mandatory legal required for the commencement from relaxed imposition to the address of the consignee in Delhi, which is R8, which is more than 2,000 kilometers. Further, after the vehicle will the generated, the consignor has generated a legal carrying on the so and so at 148 AM on 15/1/2022, about 58 minutes after the vehicle. So, if the event is not generated before the goods are being dispatched from the place of consignor, it will not be shown in any books of how will the department get any record as to whether the sales taken place from this particular consignor. Further, the document produces the date execution as action of lorry result contains for copy ensure the place of dispatch. However, the tax payer does not have any additional place of business and it is more than 70% away from the community. It is verified that the transporter has been repeatedly intensive in use of goods without even being in particular to movement of connect and is capture. Following facts are Mr. Sandy Robles was a GST institution and the GST again for Sandy Robles is proprietor is it is observed that prior to obtaining present GSTI and the same time the proprietors we actually and earlier obtained GST very so under the same GSTI in the same PAN card he had earlier had a registration in the name of Mandamus. The same registration of sumo to cancel the department from 17 to 2023. It is observed that the proprietor of both Sandy Roadline and Sandy both entities are registered at the same address. So Sandy Logistics has been given this previously from 129 and 130 for carrying goods. Details are which 5, 6 registrations are given this particular transporter is indulged with transporting of alcohol without raising events. Further, paragraph 7 is page 81. Stanley Road is also indulged in contribution of fraud and serious one. It has been penalized for market. Further, the goods vehicles also was intercepted. 5 other detentions of goods vehicle carrying alcohol for trade for non-operational behavior. And the consignment is valid status and transfer of the Stanley Road and the details of interception. Let's see the picture of it. But in such cases, handing them a release of vehicle and not they are not participating in the proceeding, letting the stars not at the 130, which will I not be able to move forward my case substantially because if an order is not passed.
Lord, this honorable court in my lord, another writ petition where is it held that generation of e-waybill within my lord hour or 2 hours is not my lord offense my lord and granted a stay. May I pass it on my lord? The interim order granted by this honorable court in a connected writ, another writ petition, similar facts. In this also my lord.
Detailed interim order.
E-waybill was not done.
That was a case for us where there was delay of 45 days in conducting the proceedings. That is not the case here.
Lord, that is not only the ground to grant an interim stay here in this case. If my lordship will permit me to read the entire order, that is also one of the ground. But it has held that generation of the e-waybill within hour or 2 hours is not a big offense under my lord act. And they find it that, my lords, my lord, that is what, my lord, that is what, my lord, that is what court said that.
You would not have any trace of this transaction.
No, that is why court held that you would have, my lord, held the proceedings under 129. There was no need to confiscate my entire, my lord, goods and goods.
Total fraud, total misrepresentation. They are playing with.
No, but insofar as convenience, what do you say? The same transporter is involved in other offenses.
That, my lord, the transporter is concerned, my lord. I do agree, but they have made a, my lord, observation in this, my lord. That I don't have any information because, my lord, when I, my lord.
You're seeking only insofar as the goods.
Goods, my lord. He's only a transporter, my lord. One more thing is that he had, my lord, LR receipt also at the time of interception.
Okay. Okay, now you take your stand insofar as release of goods.
In fact, Malaj, in these are the section 130, as I mentioned on an earlier occasion, also division bench of dishonorable subject to payment of 25% of the penalty that is demanded and furnishing the address of the remaining center. And the interim order that they are relying on Malaj is on a different particular. So I have represented the matter there, and that was a case, Malaj, where
now we are recently now we are passing orders. We are permitting on same terms, however, subject to furnishing of some security to secure the value of the goods if confiscated.
Value of the goods.
Some security. We are not saying.
Oblige, my lords.
Huh?
What, my lord, it is required under the interim order, my lord, 200% of the tax and everything is been imposed. If my lordship might pass similar order, my lord, I am grateful, my lord, and I'll comply with the order within whatever my lordship conditions, my lord.
They're saying that the value of the.
Different circumstances, like I can read the order, the interim orders in its entirety again and show Malaj why whether the single judge was inclined to grant such an order. That was because that we have to do a physical verification within 6 days. In that case, Malaj, physical verification.
Not within 6 days, within 3 days it has to be conducted.
For issuance of a notice of confiscation under section 130, we had taken a time of more than 45 days. That was the reason, Malaj, on that ground, Malaj, that conditional order gave to months.
Here still it is to take place.
We have done everything within the time permitted in law. And I can clearly demonstrate the nature of transaction.
Correct, but if you are ready to furnish security for the value of the goods, then we can see. That's the order we passed in some of the matters. You find out, let us see.
Okay.
When do you want it?
My lord, may I?
Tuesdays and Wednesdays, tax days.
Anywhere, Tuesday, Wednesday, any date, my lord, because I have, my lord, get instruction from my.
Council M. Kumar accepts notice for the respondent.
Adu adre matte nanige again my writ petition will become. My lord, my writ petition will become again, my lord. I do admit, my lord, sir. At least, my lord, till then, my lord, if they proceed with that, my lords, the purpose, my lord, I do agree, my lord, it will defect my writ petition, my lord.
But you're challenging the jurisdiction or what?
Jurisdiction is, I do agree. I question the jurisdiction and procedure, everything, my lord. In spite of that, my lord, again, it will multiply the, my lord, proceedings, if my lordship may kindly. Or else, my lord, may I request, my lord, tomorrow itself, if permits, my lord, I'll get secure instruction and I'll make submission. Till then, at least, my lords.
We'll have it on Friday. Friday.
Oblige, my lords. I'll, till then, at least, my lord, they should not.
PGA.
My lord, may I make submission? Till 9, yesterday till 9 o'clock, my lord, I have not received any kind of further actions by the, my lord, revenue. I verified that. That much assurance I can give before this honorable court, my lord. Because when matter was listed, my lords, I made inquiry with my client, and till that, my lord, at 9 p.m., my lord, we have not received any kind of any further action by the revenue, my lord.
Relist the matter on Friday. Respondent not to take further precipitative steps till the next date. When counsel for the petitioner submits that they would get instructions regarding the security to be offered in the event the court were to pass an interim order for release of the goods as sought for. Needless to state, this interim order is only subject to no order having been passed as at the present instant. Relist on Friday. In other matters, we are insisting on a security for the value of the goods, and then 200% whatever in terms of the division bench order.
39.
Huh?
My lord, in my case, my lord, though the my lord, driver, my lord, submits, my lord, tax invoice and LR receipt, the same has not been accepted. If my lordship may kindly see MO 1 and 2, my lord, they mentioned that no documents has been produced at the time of interception. But when MOE 10 comes, my lord, only they, my lord, press e-way bill. This is how, my lord, all cases are not, my lord, what revenue says.
Let us see.
Grateful.
39.
You have
I appear
experience
for the
of-
petitioner's
you have
counsel, my
experience of
lord.
both the sides. You have experience of both the sides.
I appear for the petitioner's counsel, my lord. This is a
Yes.
matter under the GST, wherein the levy of GST on a corporate guarantee has been imposed. My lord, there are other petitions already before this court challenging the levy of GST on a corporate guarantee given by a parent company for its own subsidiary to the bank. My lords,
Interim order.
yes, my lord.
Interim order.
Annexures
H.
F, G, and H, my lord, are the three interim orders in the petitioner's own case for the
H.
three past financial years. Annexures F, G, and H are the interim orders, my lord. My lords have been pleased to pass annexure F, my lord, page number 97.
Yes.
The present order is only for a subsequent financial year on the same issue.
Yes, yes. You appear.
The state, my lord.
Just show the cost type. Just show the cost type.
It's this Commissioner of Commercial Taxes, my lord, and the Deputy Commissioner. It'll be the state, my lord.
M. Kumar accepts notice for the respondents. The petitioner has called in question
Annexure B, my lord. Order at annexure B.
the order of adjudication at annexure B and submits that the identical legal contention with respect to the same assessee for the previous financial years
Yes, ma'am.
is in challenge before this court, including in WP 15927 of 2024, and this court has passed an interim order in such of the matters, and on parity, same interim order may be passed in the present matter also. Interim order passed in WP 15927 of 2024 reads as follows. In light of the same, full stop. Next. In light of the same and subject to further consideration, there would be stay of the order at
Annexure B. B, my lord.
annexure and
B, B.
proceedings, annexure B and proceedings pursuant thereto.
Thereto.
Relist the matter along with the WP 15927 of 2024.
Grateful, my lords.
Sir, do advocate senior name number. Serial number 39 do advocates to appearance. This two serial number 39. Senior advocate. Senior advocate and I have to appear on.
ಕೊಟ್ಟಿದ್ದ ಇಲ್ಲ ಸೀನಿಯರ್ 39 ಅಲ್ಲ ರಾಜೇಶ್ ಚಂದರ್ ಸೇರಿಸಿದೆ ಸೇರಿಸಿದೆ ಹೇಳ್ತಾರೆ ಹಿಂದೆ ಅಲ್ಲಿಂದ ಹಿಂದೆ ನೀವು ಹೇಳ್ಕೊಳ್ಳಿ ಹೇಳಿ ಏನಂದ್ರೆ BC ಇದ್ರಲ್ಲ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಅವ್ರ ಹೆಸರು ತೋರಿಸ್ಬಿಡಿ.
Court Master, sir.
62, serial number 440, Muhammad.
My lords, may I be permitted to make a mention, my lords?
Just
My
1
lord.
minute. Just 1 minute. Serial number? Counsel for the petitioner has filed a memo. Is that scheme there? No, correct. But same Kumar, just have a look at it. Memo. Huh? ಇದು ತೋರ್ಸು. ಇದು ತೋರ್ಸು.
This liberty cannot be
No,
available.
that's
now.
why whether scheme is there or not.
No,
I
no,
don't
no.
know. It's not.
This is a 2023 scheme. That is already over.
Please find out. Get instructions. Yes. Next.
My lords, kindly.
Yes.
I am permitted to mention, my lords, serial number 81. I had moved in urgency because there is threat of dispossession by BDA. There is a stay by this court. Now BDA says part of the land is encroached. They are independent of that. At 81, my lords, in list number 2. I'm sorry, I'm constrained to mention, my lords. 81. Yesterday I moved the matter. I have informed the BDA advocate also.
Career, noda.
81.
Murugesh is appearing, my lords.
81.
What is your apprehension now?
My lords, apprehension is survey number 61/4. Your lordship may kindly turn to IA number 4, the application for direction under section 151. The annexure to that, my lords, annexure AW. I'm sorry, there is some confusion. 22/2026, when this court has stayed the matter, insofar as that survey number is also concerned, 61/4.
No, but if there's an interim order, where is the apprehension now?
Now they are saying we will remove the encroachment. You have encroached survey number 61/3. When the matter
that we'll see. Now, unless the court pass an order, they can't do anything.
No, they have issued this intimation, my lords. Let them maintain status quo till let them survey is conducted 40 years back. I am in possession. 30-year-old trees are there in that property. It is a mini forest in Bangalore. On that ground only writ petition is filed. For it is a nursery and a forest. And kindly see, extent is also not mentioned. Your lordship may kindly see.
Just 1 minute.
I'm sorry.
Division bench upheld the acquisition, my lord. This is also included the division bench order, my lord.
Division bench, there are parties.
There are We have filed the objection, my lord. Kindly take my objection, my lord.
Division bench said insofar as nursery and other lands, you can seek for deletion. That was done and it is challenged now. Division bench.
No, but were you a party in the?
I was a party in division bench. Division bench said insofar as nursery and forest and other lands, it has to be deleted, forestries. That application was filed before BDA. Permission was granted by the division bench in the order. I am part of that order.
No, correct. We'll have to hear the matter.
My lords, it's acquisition for Nadapabu Kempegoda layout. Acquisition was challenged and the learned single judge set aside the acquisition. It came before division bench. The honorable division bench by your lordship may kindly.
No, correct. Just 1 minute. Now, madam, we'll have to hear the matter now.
Please.
Isn't it? Now they're saying that there is some threat. There's already an interim order and you have filed IA for vacating interim. So till that order is altered, you will have to hold your hands insofar. No, they are aware of the interim order. How will they do anything? I'll fix a date.
ಅಲ್ಲೇನು ಮಾಡ್ತಿಲ್ಲ
He has issued notice.
ಅಲ್ಲೇನು ಮಾಡಿಲ್ಲ
Allah, survey number extent to mention Madilla. It is a threat, my lords. He has not even mentioned the extent.
No, no, correct. Now the council is there before the court.
Please,
They say they will not do the
ನಾವ್ ಏನು
IFR
ಮಾಡಿಲ್ಲ ಇವಾಗ
vacating
ಏನು
stay.
ಸ್ಟೇ
is still
ಇರೋದ್ರಿಂದ
there.
ಏನು ಮಟ್ಟಿಲ್ಲ
So it's only after that order is altered. So I'll have it on some other day.
ಪ್ಲೀಸ್ ಮಲ್ಲ
But let
I'll
them
have it on
undertake,
some
my
other-
lords. Let them undertake, my lords.
No, the council has stated.
Please, my lords.
And there is a relist date.
My lords, if I may be permitted to mention,
Grateful.
my lords,
ಡೇಟ್ ಮೇ
a list to
ಮಲ್ಲ ಡೇಟ್ ಮೇ ಫಿಕ್ಸ್ ಮಲ್ಲ
Third of March.
ಅರ್ಜೆನ್ಸಿ
3rd of March.
ಥರ್ಡ್
Yes.
My lords, if I may be permitted to mention, list 2, serial number 99, it was adjourned in the
Yes.
morning, but the interim order was not extended, my lords. The interim order may be extended.
You must file a memo.
My
I'll
lords, it
file
was,
99.
yes, my lords, it was adjourned in the morning. If the interim order could be extended, my lords.
Interim order in operation is extended till the next date.
Grateful.
Yes.
List 2, serial number 40.
For petition, my lord.
Yes.
My lord, petitioner procuring records from farmers of rural Kerala, my lord. And after obtaining generating the invoice and e-way bill, he was transporting the goods on 11/1/2026, my lord. As per annexure C2 at page 61, my lord. The e-way bill is dated on 11/1/2026 at 3:47, my lord. On the very next day, due to the transshipment of the vehicle was changed at Tumkur, my lord, at 5:40.
Find out.
5:32, my lord.
Get instruction.
My lord, in this case, after 9 days, my lord, there have been physical verification has been done, my lord. As per rule 138.
No, correct. Let him complete instructions, and the next day we'll see what is to be done.
But find the compilation, my lord.
Correct, but let him find out what.
My lord, as per annexure,
Interim order granted by my lords in the other matter, in which senior advocate Vikram appeared. On the same condition, it may be granted because the reason being that there is a little delay in conducting the physical verification. That was the ground on which
Same
the
order.
interim order.
That
You
interim
may be
order, let
permitted
him
to
have.
pass orders.
Huh?
You may be permitted to pass orders. They're still at the stage of notice.
No, correct, but then if you sell it, what will happen?
No, we're not selling it. It is still at the stage of a notice. At the stage of notice, they have come for release of the vehicle. Vehicle has been released subject to payment of 200% of the tax and furnishing the indemnity bond for the remaining amount as determined in the notice and the valuation as arrived at in the notice. And Malaj, matters are kept pending here. In that case also, Malaj, we had part orders of confiscation and they have filed an application for amendment to amend the petition.
So orders may be passed, but
Orders will be passed, and after that they can file an application and they can get the order impugned in this. Because we can't keep the proceedings pending there, Manoj, for a long time.
so if you want release,
yes, my lord.
if you want release, we have passed an order in another matter. Have a look
My lord,
at
I am compelling in my compilation. It was annexed.
So last week I passed an
Yes, my
order.
lord.
He's
Ah.
produced
Yes, produced, my lord.
On
Yes,
same
He's
terms,
produced a copy of
yes,
the same
on
order.
same
Page
terms,
number 83, my lord.
same terms you want, we'll
Yes,
release it. But the order of confiscation must not be given effect to.
It will not be given.
It is in the notice
They
stage.
have to challenge it here. Because once we release the vehicle, my lord, there is no confiscation that can take place.
Okay, it's only an.
The portion is at page 89.
So same order. Can we pass the same order?
Yes, my lord.
Now you'll have to get instructions whether you will give a security, what kind of security? Covering the value of the goods.
Indemnity bond, my lord. I'm ready to pay give the
Indemnity bond will do here.
Yes, my lord.
And an affidavit.
I do agree with you.
Yes. You make some amendment to your law.
Yes, my lord.
Amendment has been done, my lords.
Yeah.
In fact, after the judgment in Rajiv Traders and other matters, amendment has been made, my lords, and the non-obstancy clause in section 130 has been removed. After that, and now, my lords, what we have to do, we are left with no other alternative, just to directly proceed against under 130. without even giving an order of detention, directly confiscate. But that again, my lords, we need to do an investigation before doing that.
The petitioner has called in question the.
This is a case where, my lords, consignee and consignor both are bogus, non-existent dealers.
Petitioner has sought for setting aside the order of detention / communication of detention dated 21/1/2026. Various contentions have been raised. Insofar as the interim prayer sought for by the petitioner seeking stay of the order of detention and so the petitioner sought for interim relief and has sought for the release of the detained goods and conveyance. Reliance is placed on the order passed by the coordinate bench in WP number 37627 of 2025. Petitioner submits that on same terms as the factual matrix is identical, an interim order may be
Can I submit one?
passed.
This is a case, my lords, as I mentioned, that the consignee and the consignor are not in existence, and the petitioner, my lords, is not a native of Karnataka also. So the indemnity bond will be a little difficult.
Where is the petitioner from which part?
From Kerala, my lord.
Alampur, Kerala.
Malampur, Kerala.
Then
There is no, they have used certain rent agreements, my lords, at the time of registration. Those are also not valid agreements, because the owner who is said to be, the person who is said to be the owner in the said registration certificate denied it.
then you may have to furnish some kind of security to cover the value of the goods.
My lord, as per my instructions, my lord, the no inspection was made by them, my lord.
Huh?
Though the respondents are not made any kind of inspection, straight away they have come to conclusion that there is no rental agreement.
Okay, that we'll see. But now to secure the value of the goods, if it's going to be released, and finally they're going to pass an order of confiscation, you may have to furnish some kind of security to cover the value of the goods.
My lord, in this case, my lord, the e-way bill, as on the date of transshipment, at the first instance, it was available with me, my lord.
As on the date
As
of
on the date of prior to the interception of the vehicle, the e-way bill is generated, my lord. After next day, the transit was intercepted by the
correct, but now they want the value of the goods also to be secured by some kind of security. Let you find out, you want to get
Because
some
after-
instruction.
after 9
Let us see. Relist the matter next Tuesday.
Kindly have done Friday, my lord. I will seek your instructions.
No, Friday.
Okay.
AGA accepts notice for the respondents. List the matter on Friday. You
41.
find out if you're going to, if they insist on security for the goods because you're outside the state, then you may have to consider what security you'll offer.
Secure my instructions, my lord.
41.
Yes.
My lord, in this case, after 34 days, they have made the physical verification, they issued a detention order, my lord.
Let them get instruction, we'll see. Otherwise,
After
by
34
Tuesday,
days.
they'll get complete instructions. If you want, we'll have it on Tuesday.
No, my kindly have it on Friday.
41.
In 41.
Same, is it?
Same, my lord.
Right.
In the 41, my lord, 34 days, they have made physical verifications. my lord.
Him Kumar accepts notice for the respondents. No, now then on parity because the delay, etc.
Yes, exactly, my lord.
That was the reason, my lords, that we rejected the earlier matter.
But you want to find out, you find out.
After that, my lord, they got instruction that they are non-existent seizure and not a person who is situated in Karnataka. In fact, it will be difficult for us to
Execute. Friday.
That's
then this case, my lords, which has been called on Friday. Here, this knowledge, all people, all of them are from Kerala and Tamil Nadu.
Let us see. Here is the tax. The fresh matters are there. You have 44 to 46 here. No. Pass over. Let me see. Pass over.
44.
Maybe taken up at 330.
Let us see. I have a parter tax also. I'll see how to adjust time.
Please.
Request
Yes.
330, my lords.
Let us see. I can't see. We'll see. Yes.
44, serial number 44, Mahajan, objections.
My lords, I seek weeks time to.
Weeks time granted for compliance.
45, Venkat Narayana GM.
Your Lordship, only one objection is there regarding producing a certified copy of Annexure F. However, this is the same copy which you have received from the department.
The office objection.
Also, Your Lordship, it is a GST matter pertaining to financial year 2017-18, wherein the petitioner has
Other office objection you have to clear. There
already
are other
cleared, Your
objections.
Lordship.
Other objections are there. You have to clear those.
Okay.
Now you want to take out notice.
Yes, Your Lordship, it is a very simple matter pertaining to financial year 17-18, wherein the petitioner has inadvertently classified the certain invoices pertaining to import of goods as import of services. Your Lordship, there is no revenue impact. It is a revenue neutral situation. Also, Your Lordship, there is certain procedural violations in the orders. The first one is, Your Lordship, page number 51, Your Lordship, DRC 01.
First time it is coming in.
Yes.
You find out.
Order is dated 27/10/2023. Some petitions have to be dismissed on the ground of delay and tax.
Your Lordship, it is only an inadvertent error. It is a revenue neutral situation. Also, we have received DRC 30 notice. However, the tax amount has already been recovered from the electronic credit ledger. So, Your Lordship, it can be demanded back to the adjudicating authority for fresh consideration. We will submit the reconciliation and all the documents. It is only a disclosing error. I can produce the invoices as well.
The tax has been recovered.
Let a statement be taken on record.
Yes, Your Lordship, I can show it. Page number 54 of the writ petition.
Page
54.
Yes.
Serial number 23, Your Lordship. The debit date is 25 November 2025, wherein it is stated that for March 2018, outstanding demand ID and the tax amount 5,65,223 rupees have been debited. Entire tax amount, Your Lordship, in the order, page number 40, if we see the tax column, the amounts are matching. So it is already been recovered.
Page?
Page 40.
$5,65,000.
223 rupees. Same amount has been debited from the credit ledger.
Is it so? Kim Kumar?
Please. That seems to be the tax amount. This is the tax amount.
Yes.
Where is the order? Where is the order? Page?
Annexure.
Annexure A, Your Lordship. Page number 39.
No substantial reasons have been assigned for the delay. No substantial reasons have been assigned for the delay caused in filing the writ petition. And this amount is recovered in November 2025.
Yes, Your Lordship. Despite that, Your Lordship, we have received DRC 013 recovery notice for the recovery of the entire amount, including the tax, interest, and penalty.
Now there is some discrepancy between
GSTR 1 and 3B. So, Your Lordship, there were two invoices pertaining to
GSTR 1 and GSTR 3.
3. Yes, Your Lordship. So,
Let us see.
Your Lordship, there are this two invoices wherein this is pertaining to import of goods and inadvertently we have declared that as import of services. However, the tax has already been discharged. If we can see, I have attached the DRC, GSTR 3B copy as well, where the said amount has already been paid.
The petitioner.
It is not been paid, it is recovered.
Also?
It is not paid, it is recovered.
No. No.
Petitioner has
This 3B already paid. By mistakenly we've done import of goods, import of services.
called in
Only that
question
is.
the validity of impugned order at annexure A in form GST DRC 07. The petitioner also sought for setting aside of consequential recovery notice. Petitioner sought for reopening of the proceedings and remitting the matter to the adjudicating authority for fresh consideration. It is the case of the petitioner that there has been some lapse on part of the petitioner insofar as the disclosure in the GST returns was faulty. Full stop. Submitted that transactions relating to import of goods were mistakenly shown under the column relating to import of services. Full stop. It is further submitted that the petitioner was unable to make out reply to the show cause notice
Yes, sir.
due to why due to bona fide reasons.
Your Lordship, the petitioner was not aware of the proceeding.
It's further submitted that pursuant to the order of adjudication, the demand of tax of rupees 5,65,223
Yes, sir.
has already been debited from the electronic credit ledger.
Yes, Your Lordship.
It's submitted that the reconciliation between GSTR 1 and GSTR
3B.
3B would be demonstrated before the authority as petitioner has sufficient material in support of their assertion that discrepancy as made out does not exist. Taking note that the order of adjudication at annexure A is
And recovery notice as at annexure F.
is passed without benefit of any reply on behalf of the petitioner, while noticing that the assertion of the petitioner's material to demonstrate reconciliation between GSTR 1 and GSTR 3B, and also noticing that the tax has been recovered, to be appropriate to condone the lapse on part of the petitioner and permit the petitioner to participate from the stage of reply to show cause notice. Accordingly, the order at annexure A is set aside, matters remitted to the stage of
And recovery notice
reply to show cause notice. Full stop. Consequentially, the notice for recovery at annexure
F.
F
Yes, Your Lordship.
is set aside. Matters remitted to respondent number to the sole respondent. Petitioner to appear without further notice on. All contentions are kept open.
Amount recovered shall be subject to.
Needless to state, the amount that is already debited would be subject to outcome of the
Fresh adjudication.
fresh
Take to your
adjudication. Yes, next.
46, Malayaki, MR. Karthikeyan.
I was served with a copy yesterday at post lunch, my lords. I need some time to take instructions, some 3 days accommodation.
Monday.
Please.
This is the matter in the same stage on Monday.
Great.
What is that office objection?
Yes, my lord, with respect to Annexure K, certified copy is not available from the authority, BDA. So I'll file a dispensation application under. Maybe not.
Petitioner has filed. IA for? You have filed it, is it?
Not yet, my lord, I'll file.
Petitioner submits, he would seek for dispensation of production of certified copy of the document. Release the matter in same stage on Monday. Next.
Great, my lord.
One fresh matters. Serial number 1, PM Sidmalapur.
For the petitioner, my lords.
Yes.
My lords, the scheduled property is the ancestral property of the petitioner, my lords. The petitioner, the revenue entries stands in the name of the petitioner, my lords. In the year 2013, my lords, preliminary notification was issued by the respondent, my lords, for acquisition. In the said 9 guntas of land, my lords, there is a samadhi of the petitioner's father and.
Take out notice. Third counsel so and so accepts notice for the respondent. Second respondent, AGA for the first respondent. You find out, let us see. Please, they're only seeking for consideration. Relist the matter in same stage on.
25th.
Yes.
Serial number 2, Prakash, please.
Your Lordship, this is the matter where notice under 148 issued by the jurisdiction officer is challenged. The notice is at Annexure J, Your Lordship.
I'll take notice.
So notice may be directed to department. Similar matter is at
YV Raviraj accepts notice for the respondents. In light of the contention raised. Where is the notice?
Annexure B, Annexure B.
Page?
Page.
In light of the contention that the 148 notice is issued for the jurisdictional assessing officer.
Page 13, Your Lordship.
While the department ought to have resorted to issuance of a notice under the Faceless scheme. There would be stay of the notice at Annexure B and consequential proceedings. Yes.
Your Lordship, the matter at list 2, serial number 50 is also identical, Your Lordship.
Fresh
I learned from, yeah, no, it is a B group matter. There is no interim order till date, Your Lordship.
Serial number?
They have filed an IA, my lord.
IA has been filed.
Not part of the original filing, but
Original-
they have filed an IA.
But is it same grounds? You have to verify.
No, no, in the IA, my lord, they have included this issue, power job.
So the IA has to be considered, Your Lordship. 2 IAs has
IA
been
has to
filed.
be admitted and considered.
But can the same?
Same.
List 2, serial number 50.
Now that bill, once the bill becomes the act, this is the one, isn't it?
Yes.
Huh?
Yes.
Then the matters will be solved.
It may not, my lord.
Not yet.
No, because, no, revenue is trying to say, my lord, at least my understanding, my lord, we will be arguing, my lord, that he was never divested of his jurisdiction. Even without the help of the amendment, my lord, is my.
Correct, but now matters have been disposed of from top only.
It's listed on, my lord, Saturday, the batch of matters.
Before the division.
Bench.
That also may come here only. The petitioners file an interim application raising additional grounds.
There are 2 IAs, my lord.
2 IAs.
Serial number 50.
IA 1 is for impleading, Your Lordship. IA 2 is for additional prayer, additional grounds and prayer.
And in the additional grounds, petitioners raise the contention that the notice under 148 ought not to have been issued by the jurisdictional assessing officer, but authority ought to have resorted to the national faceless assistant, ought to have resorted to the faceless scheme. IA 1 of 25 has been filed seeking to implead certain additional respondents, including the National Faceless Assessment Center. Current Counsel YV Raviraj accepts notice for the proposed impleading respondents. In light of the amendments made, said application is allowed. The applicants are permitted to come on record as additional respondents. Amendment to be carried out to the cause title. Accordingly, IA 1 of 25 is allowed. IA 2 of 25 is allowed, and petitioner taking note of the amendments made and in light of the contention now sought to be raised. Petitioner to file amended petition. Now, the interim order was not considered.
No, Your Lordship, it was
What had
not there.
happened initially, Malaj, they had challenged Malaj, the 20% audit, Malaj, they filed a stay application before Commissioner, Malaj, Principal Commissioner. We rejected the stay up petition, Malaj, stating that they've deposited only 18%. Malaj, that order was challenged before Your Lordships. Malaj, subsequently, Malaj, this is the later development. They've challenged the 148 notice, Malaj, raising this. It was issued by the jurisdictional assessing officer, not by the faceless. Malaj, since they've already paid 18%, Malaj, till the disposal, Malaj, you won't recover, Malaj. Your Lordships may kindly have it.
Till the disposal of the
writ petition, Malaj. Since we've already recovered 18%, Malaj, by virtue of stay, Malaj, by your Lordship's audit, they should not ask refund of that. Your Lordship.
So you are seeking stay of what now?
Malaj, now further recovery, Malaj. Further recovery. Pursuant to Malaj, order at Annexure A.
Right of the contention raised. Respondent is restrained from resorting to further recovery while making it clear that the amount already recovered.
Please, Malaj, your Lordships will, Malaj, at page 55, Annexure G, Malaj.
Would be subject to orders to be passed in the present petition.
Lordships may kindly refer to Annexure G, Malaj. In this, Malaj, we've stated he's deposited 18.44%. Pursuant to this, Malaj, page 55. This is the 20% order passed by the Commissioner Appeals.
No, this has been recovered.
Malaj, 18%, Malaj, at para 4. At para 4, Malaj, the last sentence, 18.44% has been recovered, Malaj.
But the amount recovered. Of 1 crore, 17 lakhs, 12,965.
Obliged.
Number 3, take Marian.
Yes.
My lords, it's a GST matter wherein subsequent to cancellation of registration, show cause notice under the order has been passed ex parte, but the petitioner made aware of the fact only upon attachment has been sent to the bank. After visiting the bank, the petitioner made aware of the fact, my lords. Apart from that, in each case of the proceedings, respondent has been flawed and they have adopted a different methodology in arriving at the demand. The basis of the show cause notice, whatever is issued, is not served to petitioner. That is the first aspect. Apart from that, based upon the show cause notice, whatever has been issued, the order is passed on the different ground. So if my lordship may have the attention, page number 37.
Yes.
Now, if you can observe, in the table, there is a GSTR 3B versus 2A. Here, there is no difference they have given in the IGST column.
Yes.
Yes, my lords, may I have your attention on page number 41, please, in the show cause notice, annexure E.
Yes. Yes.
No, if in the shortfall here, all of a sudden, see, there is a GSTR 3B, IGST column is also 0. And when compared to GSTR 2A, IGST column is also 0. All of a sudden, there is a difference of IGST, that is 1,88,000 rupees is there.
Yes.
My lord, if may I have your attention on the order, please, my lord. Page number 46.
Yes.
My lords, here the comparison has been made between GSTR 3B and GSTR 2B. The grounds on the show cause notice is issued is between the 3B and the 2A, but the order has been passed on GSTR 3B and 2B.
Where's the show cause notice?
My lords, page number 41, my lord.
So 3B is ITC claimed.
Yes, my lord. ITC, that input ITC, whatever the petitioner has claimed, that will be appearing in 3B, my lord.
2A is?
2 is auto drafted statement filed by my supplier.
By the supplier.
Yes, my lord.
So how much ITC has been collected and remitted?
Yes.
Now this is the show cause notice.
Yes, my lord.
Now here the order is 3B, that is ITC claimed.
Yes, my lord.
And 2B is?
2B is also auto drafted statement, but there is a difference for 2A and the form 2B. 2A is appearing particularly whichever the month the supplier file my return, that particular month which is go and sits in the GSTR 2A. But in case of 2B, on the same month, let's say for example for a April month, if the petitioner filed on the July, that will come and appear in the July month. But if the same is filed in July month, in the case of 2A, that will appear in April month only.
Same Kumar.
I think the taxes have been paid.
Taxes are?
Yes.
Taxes are recovered?
No, yeah, actually bank attachment has been sent, but we seek for, my lords, this is because the show cause notice, whatever the grounds issued, the order is passed in a different 75(7), which should not be deviate from the show cause notice. We request for quashing of an show cause notice.
But then this you will have to get instructions.
Quashing of show cause notice will not arise.
Huh?
Quashing of show cause notice, especially after the suffer an ex parte adjudication order, and that too in September 2024.
Yes, my lord, but the petitioner made aware of the fact only upon the bank attachment in the August, that too after visiting the bank during the December 2025 only, and petitioner is a senior citizen.
It's an ex parte order, is it?
Ex parte order.
It may be sent back.
We'll send it back.
Some cost will be
Oh, please, my lords,
amounts are also very less.
Very less, my lords.
Amounts are also very less.
The
Some cost will be levied.
My lords, the cost may not be levied, small amount, and the petitioner is also senior citizen, also suffering the health issues. In the previous petition, also the cost is already imposed, my lord, for the same petitioner. Yes.
No carry forward. Account
my lord,
sent
but-
that day itself. The
But
petitioner.
petitioner is a
For
senior
reasons
citizen.
by cost has to be following the earlier order.
The petitioner has sought for setting aside of the order in original at annexure F. It is the case of the petitioner that the order in original.
My lords, bank attachment can be removed, my lord.
No, that's in the end.
Yes, ma'am.
Annexure, where the order in original?
Annexure F.
Page 45.
45.
Annexure F.
Yes.
Would indicate that the petitioner has not replied to DRC 01, nor has attended the personal hearing. And in light of the same, the authority has proceeded to pass order on the basis of material available. Petitioner submits that he has material to demonstrate. Show cause notice at page?
Page 30, 41, my lord.
Petitioner submits that he has material to demonstrate that the discrepancy between GSTR 3B and GSTR 2A as made out by the authority does not exist. And if given an opportunity, petitioner would explain the alleged discrepancy as made out in the show cause notice. Petitioner submits that the non-reply to the show cause notice is due to bona fide reasons.
And bank attachment maybe.
Just wait.
Sorry, sir.
That is the end. I will come to that. The petitioner further submits that peruse the order at annexure F. It is admittedly the order is passed without benefit of the stand of the petitioner to the show cause notice. In light of the assertion of the petitioner that they have material to demonstrate the discrepancy between GSTR 3B and GSTR 2A, it would be appropriate to set aside the order at annexure F and remit the matter to the stage of reply to show cause notice while keeping all contentions open. Accordingly, condoning the delay, condoning the lapse on the part of the petitioner not making out a reply to the show cause notice, it would be appropriate to afford another opportunity to the petitioner to take his stand on merits. Accordingly, the order at annexure F is set aside. Matter is remitted to the stage of reply to show cause notice. The consequential demand at annexure
G, my lord.
Consequential notice to the banker of the petitioner is required to be rescinded by the respondents upon receipt of a certified copy of this order forthwith, in light of the setting aside of the order of adjudication at annexure F. Petitioner to appear before respondent number 1.
Commercial tax officer.
It's respondent number 1.
Without further notice on all contentions are kept open. Accordingly, petition is disposed of.
11th.
Yes.
4. Srihari.
Much obliged.
My lords. Challenge in this matter, my lords, is to the order under section 108, staying the operation of the appellate order under section 107. My vehicle was seized on 1st of August 25. Pursuant thereto, my lords, on 26th of September, an order was passed under section 130 of the CGST Act, levying a penalty and fine. I challenge that order before the appellate authority. Appellate authority gives a very detailed order by discussing the issues for 14 pages and coming to a conclusion that penalty is definitely leviable, but fine is not leviable because section 129 ingredients are very much satisfied, whereas ingredients of 130 are not satisfied. And penalty is levied, my lords. I pay that penalty and request for the release of the goods. But the Lordship may kindly now take to page 114. After my compliance with the penalty or appellate order, page 114, my lords. May I read, my lords? Lordship may come to page 2, para 2. Agreed by the said order, the taxable person has preferred an appeal before the Joint Commission of Commercial Taxes, Bengaluru. Para 3. The above appellate authority, vide appeal order dated so and so, has partly allowed the appeal in favor of taxpayer. The first appellate authority has allowed the appeal even though the proper officer was levied penalty in accordance with law. Para 4. On receipt of the said order by the first appellate authority, the Joint Commission of Commercial Taxes, Vigilance, Bengaluru, vide later bearing number so and so, dated 29th of January 26, has requested this office to review the above impugned order passed by the first appellate authority and requested to grant stay and initiate the revisional proceedings under section 108 of the KGST CGST Act by calling for records in the instant case. Para 5, my lords. The submission made by the Joint Commissioner of Commercial Taxes, with a letter dated so and so, is verified with reference to the appellate order passed by the first appellate authority, and prima facie, it is observed that the order passed by the first appellate authority appears to be erroneous and improper insofar as it is prejudicial to the interest of the revenue, and it is felt necessary to stay the operation of the order passed by the first appellate authority. Therefore, to verify the correctness of the order passed by the first appellate authority in order appeal number so and so, and in the interest of revenue, I hereby, with the power vested in me under section 108 subsection 1 of the KGST Act, pass the following order, and he goes on to stay, my lords. There is no reasoning given as to exactly why the power is being invoked. What is the error is not pointed out. Arbitrarily, merely on the request as highlighted in the para 4 of the order, merely on the request of the Joint Commissioner, the order of the appellate authority stayed. The order of the appellate authority, on the other hand, is a detailed order where he has explained everything and upheld the penalty while deleting the fine. When such is the case, it was incumbent upon the revisional authority acting under 108 to point out basically as to what are the errors based on which he has come to a prima facie conclusion. Without pointing anything, my lords, merely citing that there is a request and since I fail, it is felt necessary is the words used. Feeling cannot be the basis, my lords.
Yes.
I accept notice for the respondent, but may be called on Wednesday.
Learned Counsel M. Kumar.
Please give me page.
Accepts notice for the respondents. What is the matter in the same stage
Operative portion main
on Wednesday? Yes.
Serial number 5, MN20.
Lordship, give a short date, my lords.
Wednesday.
Wednesday.
Serial number 5, MN3.
The other one is a contract matter, 103. I think it should be one more.
List 2, serial number 103 is also connected matter. There are two vehicles that may be connected with the list 1, serial number 4.
List along with
list 1, list 2, serial number 103. That is, my lords. WP 4273 of 26. 4273 of 26.
Just along with WP 4273
of
2026. In that matter also, Learned Counsel AGA M. Kumar accepts notice for the respondents.
Appealing for the petitioner, my lords. My lords, the present matter is a batch matter, my lords. The list that is the WP that is listed today is the lead matter, and the same was listed last week on 11/2, my lords. And my lordship had directed the respondents to file their pleadings within 3 weeks, my lords. However, due to clerical error, this is listed today, my lords.
List along with the WP number.
It's a batch of about 8 matters.
Huh?
There are 12 matters, my lords. So this is the lead. I'll give the list, my lords. My lords, another request, my lords. Kindly a date be given, my lords, in any date in first week of March, my lords.
It is. Yeah, this you have to accept notice.
Please.
Learned Counsel Dilip accepts notice for the respondent list along with WP numbers so and so. List on. Yes.
6. Akash Kumar.
This is regarding the betterment charges. I am ready and willing to pay the betterment charges. Whereas they have imposed the interest at 1 crore 23 lakh. There is an interim strain. So far as interest is concerned, I am ready to pay the development charges. There is no provision as such for imposing the interest.
Yes.
The interest plots, I'll file my objections plots to meet the portion why interest has been levied. Plots, kindly just note, as per the provision also, my lords, the levy was as on 16th of February 2019. I understand the levy is being made now, but this was by of a gazette notification which was in the 2019. My lords, instead of perhaps, my lords, I'll file my statement with proper instructions, my lords, but the charges that were fixed in 2019 are only being retained as of now. It's not that something is being calculated as on today.
No, but how can you charge interest? If you have
I'll point out, my lords. I'll point out the reasons.
Let us see. That's on merits.
Please.
Now you are charging interest from 19.
From 19.
Okay, let us see. That's on merits.
Please. I'll file my statement to that.
Now you are saying they are required. They ought to have paid in 2019.
Please.
But since 19, my lord, no notice as such has been given to me.
Does that
It is only on my request, my lord, this demand has been made.
Let us see.
Please.
The petitioner has challenged the validity of the demand notice dated 24/12/2025 at annexure H. The United Senior Counsel appearing for the petitioner has raised various contentions, but however submits that without prejudice to the, submits that the challenge is only insofar as the interest component. Full stop. Where is the demand?
Annexure H,
Annexure H,
page 67.
Full stop.
Betterment charges, my lord, 91 lakhs went, so interest is 1 crore went.
The petitioner is permitted to pay the betterment levy of 91 lakhs 38,400 when there would be stay of the interest component of 1 crore 23 lakhs 88,666. Full stop. The petitioner undertakes to pay the betterment levy within a period of
2 weeks, my lord.
2 weeks from today.
And to sanction the plan, my lord. Suppose if I pay and if they keep quiet, my lord, I have paid the charges for the other authorities. It is time-bound payment.
Consequent to payment of the betterment levy, respondent authorities may consider the request of the petitioner for sanction of plan. It's made clear that the petitioner would be bound by final orders to be passed and in final orders to be passed.
Please. Non-compliant 7, Swami.
But for the year 2019-20, my lord, in fact, the authorities have passed 2 orders for the same financial year, invoking section 16 of the GST Act, without even issuing notice to me, without hearing me, lords.
Yes.
And in the meanwhile, they have also filed a criminal miscellaneous seeking execution of this order. And before the learned judicial magistrate first class.
Who appears?
Not state.
Name has been shown, but copies are not available.
Sir, one
We'll
next.
give a copy, sir. Meanwhile,
Let us see, let him just have a look at the papers. Relist on
Petition.
Tuesday.
Tuesday is in.
Tuesday.
Relist on Tuesday in the same stage. AG accepts notice for
Same
the
stage.
respondent. The office objection. Office objection.
Office, I'll just comply because certified copy has to be filed. That's the only objection.
Comply with the office objection. Interim.
8.
Much objection.
Number 8.
Yes.
This is, my lord, after, my lord, consent award, my lord, they have proceeded to pass a general award, my lord, and
yes,
I have served the copy on my learned friend. Yes.
Today copies are, they are entitled for, they agree for section 29(2).
Section 29(2) was of the year 2012, my lord. This is on 2013 consent award, my lord, at ink page number 57, next D.
So you find out,
Please.
when do you want?
A date may kindly be given, on specific date, otherwise.
Land Council Vasanta accepts notice for respondent.
In 3.
For respondent.
1, 2, 3.
1, 2, 3.
Yes. That made
Relist on
9(3).
in the preliminary hearing list on.
State government may be party necessary. Have to make state
At the
government
end of
as
this
a
month,
party.
you lost one date.
Hardly
not
a
a
party.
date. State government model, this is an acquisition by KDB.
KDB is state-
Order is also passed by the KD.
Correct, but yeah.
SLO's order, which I challenged.
No, but they have some supervisory, so you make them as a pro forma party.
Please.
The petitioner makes a oral request to array the Secretary Commerce and Industries.
Yes,
as an additional respondent.
Today, now itself, I'll do it.
Of the oral request made, petitioner's
I'll
request
serve the
is
copy in the
acceded
government
to
also.
petitioner to amend the past title. AJ accepts notice for the newly added respondent. Amendment to be carried out. Yes. Yes.
9, Madhu and Rao.
Lordship, in serial number 9, Your Lordship, I undertake to file the wakalat in this matter, Your Lordship. 2 weeks time may be granted to, comply the office objection. Your Lordship.
Let's I'll be filing the memo of retirement in this case, my lords. Let me also inform to the petitioner as well.
Memo of retirement filed by Council Madhu and Rao is accepted. Learned Council so and so submits that he would file wakalat on behalf of the petitioner to delete the name of Learned Council Madhu and Rao and show the name of so and so as representing the petitioner. Yes, to comply with whatever
2 weeks
office
time may be
objection.
granted. Please, Your Lord.
2 weeks time granted for compliance of office objections. Yes.
Much obliged.
Is to 230 matters. Serial number 104. Deepak Chopra. Sanmati.
Yes, to
7093. Seven zero nine three.
7093.
you are arguing which matter?
7093 we had started with. Well, that's the first year.
Yes.
Well, as you recollect, this was the case where we had filed an application under 195, which was rejected.
I don't recollect, but you can start.
Yes, ma'am. Well, this is a case where the SSE, the petitioner, had filed an application under section 195 for a nil withholding deduction certificate on payments it made to Google Asia Pacific Limited for pursuant to a reseller agreement where it was appointed as a reseller of the Google AdWords program. Because the application was rejected for 2 grounds, one on maintainability and one on the ground that the payment that I make is to be characterized as royalty, as the said expression is defined both under the Act and as well as under the treaty. And therefore, there is an obligation to deduct tax at source at 10%, notwithstanding the fact that already an equalization levy was paid for that very same consideration. What my lord has to therefore consider is whether my application is maintainable, and I had pointed out my lord's judgment in Flipkart, where my lords has taken the view that you can apply for under section 195 even for a nil withholding certificate, and the division bench has dismissed the revenues appeal against that. Then I had come to the merits, my lords, and I had pointed out the agreement that was entered into between Google Asia Pacific Private Limited and the petitioner, pursuant to which the petitioner was appointed as a reseller to distribute the Google AdWords program. My lords, the Google AdWords program is a program which is really run by Google Inc. But the right to distribute that program to people who want to advertise on it in the Americas was with Google Inc. For the rest of the world, it was with Google Ireland Limited. From 2016, for the Asia Pacific region,
that right was vested in Google Asia Pacific Limited from Google Ireland. Now, the controversy initially arose in the case of payments made by Google India, that is a petitioner to Google Ireland, and an order under section 201 was passed for the assessment years 2007-8 onwards to assessment year 2016-17, whereby the payment that was made by Google India to Google Ireland was characterized as royalty and held, it was therefore held that there was an obligation to deduct tax at 10%, and as the petitioner had not deducted tax, an order under 201 was passed seeking to recover the tax from the petitioner. Simultaneously, proceedings were taken against Google Ireland, and in Google Ireland's assessment, a view was taken that this amount is to be characterized as royalty, and hence the amount is chargeable to tax in India because the payer is an Indian entity. These proceedings went up to the tribunal, came to this honorable court, thereafter were remanded back, and ultimately the tribunal has held that the amount cannot be characterized as royalty, both in the proceedings under 201 as well as in the proceedings in the case of Google Ireland, and has accordingly upheld their contention that the amount is not chargeable to tax in India. This order has undoubtedly not been accepted by the department, but the matter has been filed, an appeal has been filed against that order, which is pending disposal before this honorable court. Plus, there were certain other advertisers who advertised directly, entered into contracts with Google Ireland or Google Asia Pacific or any other such, like for example, Facebook, to place these online advertisements. And in the case of the direct advertisers also, it has been held that there is the payment that the direct advertisers make is not to be characterized as royalty. This view that it is not characterized as royalty is also in consonance with the view expressed by the technical advisory group of the OECD, and I'll take my lords through that, as well as a high-powered committee constituted by the Central Board of Direct Taxes for making recommendations on taxation of digital electronic e-commerce transactions. So in both these committee reports, it has been specifically stated that payments made for online advertisement is to be characterized as business profit and not royalty. Now, initially, in the 201 orders, the department had relied upon several judgments of this honorable court, where a view was taken that the payment made by Google, that the payment made by an Indian entity to an overseas entity for getting a license to use software is to be characterized as royalty. The entire basis of the 201 order was that. As my lord is aware, the Supreme Court in engineering analysis has, my lords, disapproved of the view taken by this honorable court and affirmed the view taken by the Delhi High Court, and has held that this amount cannot be characterized as royalty. Now, this present order is also predicated upon the original 201 order, and I'll show my lord that. Now, once their whole stand is that we have taken up, we have in the 201 proceedings for the earlier years characterized this as royalty, and therefore for this year also it is to be characterized as royalty. In the light of the judgment of the Supreme Court and in the light of the order of the tribunal, the order cannot be sustained. That's in one of the broad summary of what the contention is before my lords. Now, I had taken my lords through the reseller agreement, but just If my lord will just see that reseller agreement for a moment. That's page 119, my lord.
Page?
Page 119. What is it? What is it?
Yes. Yes.
My lords had seen really clause 2.1. Google appoints reseller as a non-exclusive authorized reseller for Google in the territory of advertising space made available by Google through the ads program to advertisers, as well as any other ads program and services which the parties may agree upon in future, which specific terms and conditions shall be contained in an exhibit to the agreement, all under and in accordance with the terms and conditions set forth in this agreement. The reseller shall conduct its business for its own account in its own name and not as an agent, employee, partner, or franchisee of Google. In performing its obligations hereunder, the reseller shall only refer to itself as an authorized Google reseller of the ads program. Reseller may not solicit business from and shall not sell advertising space to, even if unsolicited, any entity that does not have a principal place of business within the territory. For the avoidance of doubt, an entity's principal place of business will be determined by the place of such entity's registration or incorporation as applicable. All inquiries by such entity for sale of advertising space shall be referred to the designated Google contact within 3 business days. Reseller agrees to market, offer, and sell advertising space to advertisers in the amounts and according to the terms set forth in Exhibit A. Google must sell to advertisers and liaise with qualified advertisers directly with the reseller's own sales force and customer infrastructure. Reseller shall perform its obligations hereunder in a professional manner consistent with reasonably applicable industry standards and in accordance with this agreement. Reseller will sell the ads program in accordance with the training provided by Google. Failure to do so and unauthorized representation to advertisers will constitute a material breach of the agreement. Then my lords will see clause 2.6. Reseller will provide after-sales service to advertisers in accordance with the instructions, training, and standards of Google and as provided in Exhibit A. And then there is a clause with regard to training, which is clause 3.2. Google agrees to train the reseller as set forth in Exhibit A. So my lords, the obligation of Google is to train the reseller and to provide the ads program to the reseller for subsequent sale to the advertiser. Google India, that is the petitioner's obligations, are to sell and market this program in India and to render after sale services to the advertisers. So what my lord has to consider is that the consideration which is paid by Google India to Google Asia Pacific pursuant to this agreement, would such consideration be regarded as a payment by way of royalty for use of the intellectual property that is provided for in Article 12 of the India-Singapore Double Taxation Avoidance Agreement. Whereas the India-Singapore DTA definition of royalty is narrower in scope than the definition under the Act. So for the, I think we can just confine ourselves to the definition in the treaty matters. So that pointed out that there is a right in Google India. You will just see clause 5 of the agreement at page 121 to use certain brand features for the purpose of marketing. Just see clause 5. Google shall own.
Just one basic fact, just to clarify understanding. Now this reseller agreement is between Google Asia Pacific and the reseller.
And the petitioner.
And the
petitioner. Google India. He is the reseller.
Yes. Now the payment is being made
by India to Google Asia Pacific. And the consideration is
the platform is being provided by Google India.
No, man. The Google India is a distributor of the ads program. Google India has no rights in the platform at all.
Now who is the reseller?
The reseller is Google India.
So the platform is provided by Google Asia
Google
Pacific.
Inc. Really, Google Inc. has granted a right to Google Asia Pacific to sell the AdWords program in the territories of Asia Pacific.
Yes. Now the payment, where is the clause?
Right, now that you see in the exhibit, my lord. Exhibit 1 to the agreement, which is at page 127. Clause 4. In consideration of the purchase of advertisement space as a non-exclusive authorized reseller under this agreement, the reseller shall pay Google an amount, the payment amount, equal to the adjusted net revenue invoiced by the reseller from qualified advertisers within the territory pursuant to this agreement. In the event the monthly total of the gross amounts invoiced to advertisers by the reseller is less than the minimum monthly purchase as defined in Article 5 below, the reseller shall remit a payment amount equal to the minimum monthly purchase amount. For the purposes of this section, adjusted net revenue shall mean the gross amount invoiced by the reseller, net of freight, insurance, value added and similar taxes, duties and similar charges, all credits, discounts and amounts refunded to qualified advertisers pursuant to this agreement, reseller remuneration to be determined from time to time based on mutually agreeable terms and conditions and subject to the adherence of arm's length principles. So suppose today, my lords, the reseller collects say 100,000 from the advertise in a particular month. Its expenses are 10,000 and its arm's length price is say 5%. That's another 5,000. Then the price that the reseller has to pay Google Asia Pacific is 85,000. 100,000 minus 10,000, which is the expenses, minus 5,000, which is its remuneration. So now what my laws has to consider is this payment of 85,000 to Google Asia Pacific. Is it a payment which can be characterized as royalty, being a payment made by India for the use of the copyright of any literary, artistic, scientific work, or for a payment for use of a process, equipment, etc. Well, also bear in mind that the reseller does not use this program. It is the advertiser who advertises his product. For it to be characterized as royalty, it has to be a payment for use of an intellectual property right.
The reseller is not equivalent to or is not equivalent even to a franchisee.
No.
Because it's only a facilitator.
It's like it's like a distributor. Today, it's an intangible product. But otherwise, just consider this, my lord. Today, you have media advertisements. So the Bennett Coleman group can appoint somebody as a reseller to actually sell ad space on various publications to advertisers. So what people do, you have these media buyers who buy out advertising space for a lump sum and then sell it to their clients. Here, because I think the difference is that there the publication house fixes the ad tariff, or the television channel will fix the ad tariff. In a AdWords program or in any online program, it is the advertiser who determines how much he is willing to pay. Because if somebody clicks on my ad, then I will pay 5 rupees per click. But if somebody else is willing to pay 50 rupees, his ad will be visible first before my ad will be visible. So therefore, it is a question of you deciding what price you are going to pay as an advertiser to get greater visibility.
But where is this royalty defined?
Because royalty is defined in the treaty. Please see the India Annexure W to the petition. The India-Singapore Treaty. It starts at page 385. Please go straight to page 390. Article 12.
No.
Para 3 defines the term royalty.
Now, is there any reference to this under the substantive tax legislation? Royalty?
Yes. Under the Income Tax Act also it is defined in section 916. Explanation 2 to section 916.
Now, this is subject to the definition, and the treaty definition
is narrower, therefore the treaty definition has to
supersedes.
Supersedes.
That is by virtue of?
Well, there is a board circular and several judgments of the Supreme Court. And now a statutory provision in subsection 2 of 90.
Subsection 2 of?
Section 90.
Let's have a look at the provision.
Okay. Well, just see subsection 2. We'll find it at page 1.731. Where the central government has entered into an agreement with the government of any country outside India or specified territory outside India as the case may be, under subsection 1, for granting relief of tax, or as the case may be, avoidance of double taxation, then in relation to the assessee to whom such agreement applies, the provisions of this act shall apply to the extent they are more beneficial to the assessee.
So only if it's more beneficial, then the act
Act will apply, otherwise the treaty will apply.
That's how it's.
And if my lord will just see the paper book, so there's a case law paper book which we have filed.
There. Yes.
No, the judgment of the Supreme Court in engineering analysis starts at page 364. But if my lord will just see at page 366. Just the head note first. Definition of royalty in the DTAA.
Paragraph?
Well, let's see at page 366 in the head note first. The bullet point with the beginning heading, definition of royalty in the DTAAs. Has my lord got that?
$366. Yes. Yes.
Firstly, it will be seen that when Article 12 of the India-Singapore DTAA defines the terms royalty in sub-article 3 thereof, it does so stating by such definition is exhaustive. It uses the expression means. Secondly, the term royalties refers to payments of any kind that are received as consideration for the use of the right to use copyright in a literary work. As opposed to this, the definition contained in explanation 2 to section 916 is wider in at least 3 aspects. It speaks of consideration, but also includes a lump sum consideration, which would not amount to the income of the recipient chargeable under the head capital gains. When it speaks of the transfer of all or any rights, it expressly includes the granting of a license in respect thereof, and it states that such transfer must be in respect of the copyright of any literary work. However, even when such a transfer is in respect of copyright, the transfer of all rights in relation to copyright is a sine qua non under explanation 2 to 916 of the Act. In short, there must be a transfer by way of license or otherwise, all or any of the rights mentioned in section 14B, read with section 14A of the Copyright Act. And then my lord will just see.
So copyright under the DTAA is limited to, royalty under the DTAA is limited to
Because there it was only
payment in consideration for
the use of
literary work.
A copyright of a literary work.
Only.
No, scientific work, musical work, artistic work, everything. But the point was, really the distinction is between a copyright right which is granted to you and a right to use a copyrighted article. Today, there is a copyright in a software program. When I get a license to use Microsoft Word, I am using a copyrighted article. I am not using the copyright in any manner. I don't have a right to reproduce. I don't have a right to make copies, to make modifications, nothing of that sort. My lords, it's like, in simpler terms, today, my lords, Sweet and Maxwell gives Eastern Law House a right to make 100 copies of Palmer on company law and sell them in India. Then they are giving him a copyright right to make 100 copies. But if Sweet and Maxwell sells 100 copies of Palmer on company law to Eastern Law House, who then distributes those 100 copies in India, what he's bought is a copyrighted article.
Yes.
That is the distinction. And then, my lords, will also see para 97 of engineering.
Para
97 at page 414. No, just this example is there in para 97. This ruling of the AR flies in the face of certain principles. When under a non-exclusive license, an end user gets the right to use the computer software in the form of a CD, the end user only receives a right to use the software and nothing more. The end user does not get any of the rights that the owner continues to retain under section 14B of the Copyright Act, read with subsection A 1 to 7 thereof. Thus, the conclusion that when computer software is licensed for use under an end user license agreement, what is also licensed is the right to use the copyright embedded therein is wholly incorrect. The license for use of a product under an end user license agreement cannot be construed as the license spoken of in section 30 of the Copyright Act. As such, EULA only imposes a restrictive condition upon the end user and does not part with any interest relatable to any rights mentioned in sections 14A and 14B of the Copyright Act. And then, my lord, will see para 100. Also, any ruling on the more expansive language contained in the explanations to section 916 of the Act would have to be ignored if it is wider and less beneficial to the SSE than the definitions contained in the DTAA as per section 90 subsection 2 of the Act, read with explanation 4 thereof, and article 3(2) of the DTAA. Further, the expression copyright has to be understood in the context of the statute which deals with it, it being accepted that the municipal laws which apply to the contracting states must be applied unless there is any repugnancy to the terms of the DTAA. For all these reasons, the determination of the AR in Citrix Systems Asia Pacific Private Limited does not state the law correctly and is thus set aside. The High Court of Karnataka, in a judgment impugned in the various appeals before us, namely Samsung Electronics, also held that what was sold licensed by way of computer software included the grant of a right of interest in copyright and thus gave rise to a payment of royalty, which then required the deduction of tax at source. The reasoning of this judgment in the appeal is set out as follows. Because then they've set out the reasoning of the High Court, and then in para 102, the reasoning of this judgment also does not commend itself to us. The same error was made by the AR in Citrix Systems Asia Pacific Private Limited was made in this judgment. That is, no distinction was made between computer software that was sold licensed on a CD, other physical medium, and the parking of the copyright in respect of any of the rights or interest in any of the rights mentioned in sections 14A and 14B of the Copyright Act. This being the case, the reasoning of this judgment suffers from the same fundamental defect that the ruling in Citrix Systems Asia Pacific Private Limited suffers from, by no stretch of imagination, can the payment for such computer software amount to royalty within the meaning of Article 12 of the DTAA. In another judgment of the High Court of Karnataka, in CIT versus Synopsys International, the High Court relied upon the expression in respect of in 916 and held as under. Then they extract from that judgment, and then in para 105, the reasoning of the High Court of Karnataka in Synopsys does not commend itself to us. First and foremost, as held in Swastik Tobacco Factory, the expression in respect of and used in a taxation statute is only synonymous with the words on or attributable to. Such meaning accords with the meaning to be given to the expression in respect of contained in explanation 2.5 in section 916 of the Act, and could not in any manner make the expression otiose, as has been wrongly held by the Karnataka High Court. Secondly, section 16 of the Copyright Act, which states that no person shall be entitled to copyright otherwise than under and in accordance with the provisions of the Act or of any other law for the time being in force, has been completely missed, thus making it clear that the expression copyright has to be understood only as stated in section 14 of the Copyright Act and not otherwise. Thirdly, when it comes to a computer program, the High Court in Synopsys was wholly incorrect in stating that the storage of a computer program per se would constitute infringement of copyright. This again would be directly contrary to the terms of 52(1)AA of the Copyright Act. Fourthly, the High Court is not correct in referring to section 916 of the Income Tax Act after considering it in a manner that has, and then applying it to interpret the provisions under the Convention between the Government of the Republic of India and the Government of Ireland for the avoidance of double taxation and for the prevention of fiscal evasion with respect to taxes on income and capital gains. Article 12 of the aforesaid treaty defining royalties would alone be relevant to determine taxability under the DTAA, as it is more beneficial to the SSE as compared to section 916 of the Income Tax Act as construed by the High Court. Here again, 90 subsection 2 would, with explanation 4 thereof, has not been properly appreciated. Fifthly, the finding that when a copyrighted article is sold, the end user gets right to use the intellectual property rights embodied in the copyright, which would otherwise amount to transfer of an exclusive right of the copyright owner in the work, is also wholly incorrect. For all these reasons, therefore, the judgment of the High Court at Karnataka in Synopsys also does not state the law correctly. Then they refer to the Delhi view. And then if my lord will see paragraph 117 at page 424. The conclusions can be derived on a reading of the aforesaid judgments are as follows. Copyright is an exclusive right which is negative in nature, being a right to restrict others from doing certain acts. Copyright is an intangible, incorporeal right in the nature of a privilege, which is quite independent of any material substance. Ownership of a copyright in a work is different from ownership of the physical material in which the copyrighted work may happen to be embodied. An obvious example is the purchase of a book or a CD, DVD, who becomes the owner of the physical article, but does not become the owner of copyright inherent in the work, such copyright remaining exclusively with the owner. Parting with copyright entails parting with the right to do any of the acts mentioned in section 14 of the Copyright Act. The transfer of the material substance does not, of itself, serve to transfer the copyright therein. The transfer of ownership of the physical substance in which the copyright subsists, giving the purchaser the right to do with it whatever he pleases, except the right to reproduce the same and issue to the public, unless such copies are already in circulation, and the other acts mentioned in section 14 of the Copyright Act. a license from a copyright owner conferring no proprietary interest in the licensee does not entail parting with any copyright and is different from a license issued under Section 30 of the Copyright Act, which is a license which grants the licensee an interest in the rights mentioned in Section 14A and 14B of the Copyright Act, where the core of a transaction is to authorize the end user to have access to and make use of a licensed computer software product over which the licensee has no exclusive rights, no copyright is parted with, and consequently no infringement takes place, as is recognized by Section 52(1)AA of the Copyright Act. It makes no difference whether the end user is enabled to use the computer software that is customized to its specifications or otherwise. A non-exclusive, non-transferable license merely enabling the use of a copyrighted product is in the nature of restrictive conditions which are ancillary to such use and cannot be construed as a license to enjoy all or any of the enumerated rights mentioned in Section 14 of the Copyright Act or create any interest in any such rights so as to attract Section 30 of the Copyright Act. The right to reproduce and the right to use computer software are distinct and separate rights, as has been recognized in State Bank of India, the former amounting to parting with the copyright and the latter in the context of a non-exclusive EULA not being so. Consequently, the view contained in the determination of the AR in Dassault GeoQuest and the judgments of the High Court of Delhi in Ericsson, Nokia, ZTE, Infrasoft state the law correctly and have our express approval.
Is non-exclusive use conferred? Is it, it does not go with royalty or it could?
Whether it is exclusive or non-exclusive does
Doesn't
not make any difference.
Is the nature of
what is a right granted? Well, suppose today, let's take the Sweet and Maxwell example. Sweet and Maxwell gives Eastern Law House the exclusive right to sell its slew of publications in India. Whenever they need, they will import it and sell it. Whether it be Palmer's, it be Chitty, it be Benjamin, whatever it is.
It's still the finished product.
Absolutely. But if you give them a right to make copies and sell them in India, then it is grant of a copyright. Or take an example of music.
So either Indian reprint or,
absolutely,
or the right to translate.
Absolutely. Look at music. Well, today, suppose in the good old days when records used to be there, I may give HMV a right to make the records and sell them in India. Then, of course, HMV India has a right to reproduce the copyrighted work. And therefore, when HMV India makes a payment to HMV UK, it is making a payment for a copyright right. But if HMV India just imports 1,000 copies of a record and then sells it, it is buying a copyrighted article and selling it. And I, as a purchaser, have no right to make copies of that music. Today, of course, that has changed completely because I think now nobody buys records and CDs. But that is the position in law. Now look at the definition in the treaty, my lords, for a moment. Go back to Article 12.
Page?
Page 390.
Yes.
That's paragraph 3. The term royalties as used in this article means payments of any kind received as consideration for the use of or the right to use any copyright of a literary, artistic or scientific work, including cinematograph film or films or tapes used for radio or television broadcasting, any patent, trademark, design, model, plan, secret formula or process, or for information concerning industrial, commercial or scientific experience, including gains derived from the alienation of any such right, property or information. And B, any industrial, commercial or scientific equipment other than payments derived by an enterprise from the activities described in paragraph 4B or 4C of Article 8. So my lord will see that when Google India makes a payment to Google Asia Pacific, for it to be characterized as royalty, it must be a payment made as consideration for the use of a copyright or a patent or a trademark or a design or a model, plan, secret formula or process, or for industrial, commercial or scientific. Where is the use by Google India of any of these rights?
You're allowing the advertisers to make use of this.
I'm not allowing it. The advertiser, by entering into a contract,
makes use of this.
Manas, I don't know whether he makes use of these rights also. He doesn't make use, because there is a facility which is provided where you can display your ad. There is, Manas, use of intellectual property must mean that it is within your dominion and control. There is no such right which is granted to. But take a simple example. Today, if I hire a taxi for going from place A to place B, because I'm not using the cab. The cab driver is facilitating my transport from place A to place B.
Now here, A and B, there's a slight difference.
Yes, madam.
A refers to broadly some intangible right of an intellectual property, we could say.
Right.
B refers to a slight variation.
Right. Use of any industrial, commercial or scientific equipment. It still has to be a payment for use of. Because the equipment is used, the servers, the infrastructure at the Google backend is used by that entity to provide the service to the advertiser of loading his ad, which will become visible to a prospective customer when he conducts a search. First, to understand how this program works, let's just see the tribunal's order where they have explained this in detail. Now, just for a moment, if my lord will see the tribunal's order, which is Exhibit C at page 29. First, actually, if I can show my lords page 307, then I'll go back to 29. What is the reason? Just if my lord will go first to page 297. Paragraph 2. 297. Has my lord got that? Paragraph 2. Google AdWords program is a self-serve online advertising service provided by Google for businesses wanting to display ads on web properties like Google search engine, etc., advertising space. The purpose of the AdWords program is to display the ads on web properties like Google search placed by advertisers to users who are interested in the product service offered by the said advertiser. This is no different from display of ads in newspapers, magazines, and other advertising mediums. The Google AdWords program enables the advertisers to create, change, and monitor the performance of sponsored links, to set a budget for advertising, and only pay when people click the ads. Advertisers who use the AdWords program can create relevant advertisements using keywords or phrases that may match with a search query relevant to the business of such advertisers that people input while using the Google search engine. Multiple advertisers can choose the same keyword. For example, if an advertiser delivers fresh flowers, it could use fresh flower delivery as one of the keyword phrase in its advertising campaign while using the AdWords program service. When a user of Google search engine searches on the Google search engine with the search query fresh flower delivery or a similar term, the advertiser's advertisement might appear next to the organic search results on Google search engine. In Annexure C, when user of a Google search engine has entered the search query, fresh for on the top are advertisements that have been uploaded by different business entities and are called a sponsored link, specifically identifiable with a small tab under the web link referred to as an ad, whereas items below are organic search results. Well, that if you see page 307, it will be clear. Well, just for a moment, go to page 307. Well, just see the first four entries. So somebody did a search for fresh flower delivery, which is in the search box, my lord. The first four entries are ferns and petals flower delivery in 4 hours, and there is a small box below that ad. Has my lord got that? Then there is orders flower delivery India, again ad. Send flowers bouquet online, again ad. Then buy fresh flower online, again ad. And then comes the organic search results starting with ferns and petals. There my lord will see there is no ad. Now if I have searched for fresh flowers delivery and I click on ferns and petals in the organic search delivery, then ferns and petals does not have to pay anything to Google. But if I click on add that line, then ferns and petals will have to pay Google.
Yes.
And then go back, my lords, just go back to page 297 again. Sorry to take you back, my lords. Clause C. The advertiser sets a budget for payment on the online web interface of Google AdWords program and only pays when a user of the Google search engine clicks on the sponsored link of such advertiser. This is called cost per click basis, CPC. For example, if the advertiser sets a budget of rupees 100 for a month and his CPC is Indian rupees 5, there are two possibilities. The sponsored link of the advertiser gets clicked 20 times in that month. In such a case, the advertiser has to pay 100. Thereafter, the sponsored link of the advertiser does not appear at all during the month. When a user of the Google search engine inputs the search query fresh flower delivery, the sponsored link of the advertiser does not get clicked at all during the month. In such a case, the advertiser has to pay nothing. It is pertinent to point out that the advertiser does not pay for the click made by a user of the Google search engine on the organic search results of such advertisement returned by the Google search engine. An advertiser pays for the click made by the user on the sponsored link only. So the person who's actually doing the search is the person who's using the facility. As a consequence of the potential customer user of the facility, the ad is displayed. Well, it's today when I pay, the whole object is this, that today when I pay for a media ad or for say a television ad, there will be a viewership because the media publication will charge the amount based on what their viewership is or what their readership is. But they may not be my targeted customers. So the idea of putting these digital ads is that it will reach a targeted customer only. That is the essence of digital marketing. So I can choose that I am doing fresh flower delivery in the city of Bangalore. So I will choose that only when a user who's based in Bangalore will click on it, only then will I pay. So I can target a delivery in this fashion.
It's filtered.
Absolutely. Now it's today, if my learned friend and I both do the same search at the same time, we'll get different ad results because he's from Delhi, I'm from Bombay.
Yes.
Now, when Google India is making a payment to Google Asia Pacific for this, where is the use by them? What my Lord has to determine is that, and that is precisely what the tribunal has found. Because in the light of this, just see the tribunal's order.
I think that will continue.
Very well. But could I suggest, if it is possible, if I could get 2 consecutive days, well as 3rd, 4th of March, or next week also, I don't mind coming on 25th, my lord. 25th, 26th.
But now there are 2 things both of you will have to take a call. There is a likelihood of the roster changing.
I see.
So if you feel that since you could be treated as partnered, both of you must take a call. I don't want to impose.
No, I have no problem.
Can be treated as partner. We also don't have any problem.
So then I'll put it on 3rd and 4th. 3rd, I'll have it.
Because that's a vacation period for my the learned HG also, so he probably be able to come and finish it.
Let us see. My task won't be finished.
Yes, sir. At least our task will be over.
With the Supreme Court now giving directions, I'm going to be very difficult when I'm going to reserve your matter, irrespective of when you finish.
Very well.
The Learned Senior Counsel, so-and-so's argument remains inconclusive. As arguments have been advanced, the arguments advanced are substantial. Matter is treated as part heard. Relist the matter for further hearing on 3rd of March at 2:30. We have some difficulties. What happens is that when there are big matters, we have to eventually reserve it. And sometimes, even though we reserve, we may have 4 or 5 other matters reserved. So we take it up chronologically. So this time pressure sometimes
I can understand.
is very difficult.
Well, I think the problem is the Supreme Court judges take sometimes more than 10 months to deliver.
No comments.
Yes, I wanted to clarify that tribunal judgment has not attained finality. We
Which
are in
one?
appeal. The tribunal judgment given upon the Leonard scenario, it has not attained finality. We are in appeal before the DB.
Yes, we'll point out that also. I'll deal with that.
Yes.
Whereas we've already filed a short note for my lords just to.
Where is that? Where is
that? Was circulated.
Our copy. Our copy. Another copy. If
I've given a copy. You want another copy, man?
you just give a copy. And then if you have scanned files,
yes, sir.
Can you email it?
Certainly.
Now the register. You can just collect the email ID. Yes.
Obliged.
Suyog, Supri. I wanted to point out two sections under Koka, my lords.
Koka.
Could I pass on the Koka? Section 24, my lords, of Koka. Though the head note, my lords, in section 24 commences with cognizance of and investigation into an offence. 24(1)(a). Now, this is a prerequisite, my lords, for the invocation of Koka. 24(1)(a). It would not only be the prerequisite for invocation of Koka, but would also be a prerequisite for investigation under this act. Could I read 24(1)(a), my lords?
Correct, but why are we getting into this?
My lords, now my lords has set aside the order passed under 24(1)(a).
Yes.
Now, what would be the effect of setting aside an order passed under 24(1)(a), my lords? Any other consequential act. Now, my lords, here the extension which has been granted would be under section 22, that extension of time, my lords, which I will point out next.
Yes.
Now, if the base, the foundation itself of granting approval has been quashed, then quite obviously, my lords, orders that are passed thereafter will also have to go. It's virtually in the nature of it being null and void. So in this context, my lords,
But
two portions we get under. Yes.
Only one point.
Yes.
You may have to deal. they may contend, I don't know what they're going to contend, that action taken when it was still in, when the extension was still in force. After that order goes, what happens is what we are
That is the main contention which they can take, my lords. So that's the reason, my lords, my argument would be twofold. My first argument would be, my lords, as soon as this honorable court quashed the approval order by its order dated 19/12/2025, the foundation of Koka goes. So automatically the two extensions that were given for 45 days, 30 days automatically goes, is the first contention that I would urge. Now, if that is going to happen, then, my lords, we are back to a stage where the investigation has to be over in 90 days.
Now, if that were to be so, then this first limb of your argument, immediately on the lapse of 90 days, since no charge sheet was filed,
And if I filed the application seeking mandatory bail, my lords,
it has to be granted.
yes, my lords. So this 90 days, so far as accused number 1, expired on 23/11/2025. Now, the second leg of argument, my lords, without prejudice to this contention in saying automatically those two orders go. So we don't even have to see what date they get extended to, because the orders would have to be read as a nullity. My lords, that goes on the principle of saying if the foundation falls, the superstructure falls. That's based on that principle, for which, my lords, I will give the necessary case law. Now, dehorse that argument. Now, even if we take, my lords, that the approval order was pending consideration before this honorable court. This honorable court on 19/12/2025 set aside the approval order. So the extension that was granted will at best be only till 19/12/2025. The day when this honorable court, by a judicial order, set aside the approval order. If that was to be so, my lords,
Immediately on the next day.
next day, if they have filed their charge sheet before I file my application for bail, I'm not entitled to bail. But if I have filed my bail application before they file their charge sheet, I'm entitled to bail. Now, I say so, my lords, because the division bench of the Bombay High Court took a view of that nature. They pointed out two scenarios, my lords. The second scenario was such a scenario where, my lords, after the approval, those were cases, what happened was, initial approval was granted, extensions were granted. Then, my lords, the second part of this 24(1) that I was pointing out deals with granting of sanction. Now, sanction was not granted. So when they say, I'm sorry, so 24(1) has two parts to it, my lords. 24(1)(a) dealing with grant of approval, that is for the purpose of invoking the act and for the purpose of investigation, and it's an administrative order. The second part, my lords, 24(2). Please notice, my lords, the second part of it, no special court shall take cognizance of any offence under this act without the previous sanction of the police officer not below the rank of an additional director general of police. Now, this is for the purpose of taking of cognizance. This should have nothing to do insofar as the investigation is concerned. So, my lords, there's basically, we get a double filter here, my lords. The first would be getting an approval under 24(1)(a), which is for the purpose of investigation. The second that we get is for the purpose of the court taking cognizance. But, my lords, if there is going to be a case like the one that we have here, where the very approval itself is taken off, then, my lords, no portion of Koka will even apply. Now, in this context, my lords, if we now see section 22, the extension of the period of investigation. Well, section 22, the proviso in section 2. So, my lords, under 24, both under 1 and 2, they're administrative orders. But when it comes to extension of time, it's a judicial order. Now, that is relatable to the proviso. Section 22, 2B, provided further that if it is not possible to complete the investigation within the set period of 90 days, the special court shall extend the set period up to 180 days. The prerequisite is on the report of a public prosecutor indicating the progress of the investigation and the specific reasons for the detention of the accused beyond the set period of 90 days. So these are the prerequisites, my lords. The prosecutor will have to explain why they need the additional period and why they need to keep the accused detained. On this basis, court would independently apply its mind before granting the extension. This becomes a judicial order. So in my respectful submission, my lords, there are cases, as I will point out from the Bombay High Court, which has been relied both by the magistrate court and by the special court. Those were cases, initially approval was granted. Subsequently, sanction was not granted. So the Bombay High Court took a view, my lords. Since the approval, there's no fault with it. Investigation could go on. So extensions are valid. And since, my lords, the order, judicial order of extending it has not been set aside, we would not interfere. You're not entitled to statutory bail. A division bench took that view. In the same scenario, my lords, division bench also put in the second category of saying, look, let's view this from another point of view. When is it that the sanction was not given? They put the date there. They say if on that date, that whole day is there for the charge sheet to be filed because the cause of action will arise from the next day onwards. If on that day the charge sheet is filed, then you are not entitled to it. But if on that same day you have filed your default bail, not waited for it to come to the next day because your cause of action arises the next day. If you have done it on the same day when the sanction is denied, then it's premature. You should have done it on the next day. And if you had done it on the next day and charge sheet is filed after you have filed your application, your right becomes indefeasible. This is a scenario which they have given, which I will now point out, my lords. My lords may have, from the judgments that I have given, just prior to that division bench order, my lord's order may become very relevant, my lords, where my lords would say the whole initiation is bad. That commences at page 69, my lords, in the petition set itself, order dated 19/12/2025. My lords, the relevant portion are two paragraphs, paragraphs 43 and 44 at page 101 and 102. Paragraph 43 may be noticed. Paragraph 43, page 101. My lord would have paragraph 43, my lord.
No, this order has not been stayed.
No, they've challenged it. It is posted for hearing, not stayed.
Only says it won't be used as a precedent in
it can't be used as a precedent anywhere else.
In other matters.
Yes.
In the sense of position of law.
Absolutely. Absolutely. My lords, if paragraph 43 is noticed, what is it that the court would do? It says the very initiation of Koka is bad. Now 43, the invoking of the provision under Koka would not stand legal scrutiny. While it is indeed correct that invocation of Koka is against the crime and not the accused, however, the legal requirement would mandate that there has to be continuing unlawful activity for which the ingredient of 2(1)(d) of Koka requires to be satisfied, which is absent in the light of the discussion made above. Accordingly, in light of order of approval not standing legal scrutiny, in light of the discussion made, supra, the order of approval at Annexure K dated 12/8/2025 is set aside. As the invocation of Koka is against the offence, the order of approval is not particular to the offender and its setting aside in the present petition, though at the instance of one accused, has the effect of setting it aside in its entirety. Accordingly, the writ petition is allowed. Now, my lords, this particular proceeding, it did not happen overnight, my lords. This entire proceedings where challenge to Koka took place. If the order sheet is seen,
Thanks to your arguments.
yes, my lord, it did take some time. I'm sorry. My lords, it took place between 16/10/2023 to 19/12/2023, nearly for 2 months, 3 days, my lords. The petition that was filed, it was filed on 14/10, my lords. From 16th it commenced. It went on till 19/12/2025. So it was not that the prosecution was not aware at all, my lords, that the possibility of Koka going is there or not there. It's not something which happened overnight. Now, in a position like this, my lords, on 19th, the pronouncement of this order setting aside Koka. Which means, my lords, the prosecution, if it was vigilant, would have filed the charge sheet forthwith. Now, my lords, under BNSS, there is an change to what we got from the CRPC, my lords. CRPC 173 is the filing of the charge sheet. Equivalence now is 193 of BNSS. If my lords would once notice 193 of BNSS, my lords. Conventionally, my lords, a charge sheet with all the particulars had to be placed before the court, my lords. Now it is no longer required to be done in a hard copy. It can be done electronically also. Please notice, my lords, 193. One may be noticed, my lords. As soon as the investigation is completed, the officer in charge of the police station shall forward, including through electronic communication. This is what we find as an addition. So 19th, my lords, after this order was passed, if the charge sheet, they intended filing before we sought for default bail, they could always do it electronically. Now, my lords, 19th, the charge sheet is not filed. 20th, it is not filed. 21st, it is not filed. 22nd, my lords, after I filed my application for default bail at 12 noon, at 5:45 p.m., the charge sheet is filed. So more than 72 hours after the order passed by this honorable court, during which time our application seeking default bail was on record. And in my respectful submission, my lords, that is where the precedent that we have, ED versus Kapil Wadhwani, Jigar, and all other judgments, my lords, which says that once your right is accrued and you have filed your application prior to filing of the charge sheet, your right becomes indefeasible. And it is mandatory to grant and statutory bail.
We'll continue tomorrow.
Please.
My lord, if I may
My
be
lord.
permitted to make a mention, my lord. list 2 serial number 75, my lord, past 3 dates it has not reached. There is no interim order. It's an arbitration petition seeking interim measure, and there are interlocutory applications seeking temporary relief as well. My lord, may be recorded that it may be listed in list 2 fresh matters, my lord, so that it may reach on the next date, my lord.
My lord, list.
Wherever interim orders have not been passed,
My lord.
you make a, wherever interim orders are not passed, I've given instructions to the court officer, you please make a mention. Those will be put higher up in the list in preliminary hearing so that it reaches. So you
Grateful, my lord.
make a mention to the court
It
officer.
has been not.
My lord,
reached.
same
That is
reason,
the
my lord.
Problem, my lord, at 2:30, my lord. Serial number 52.
Until I finish my 2:30 list, I'm not going to take any matter at 2:30. If you make a request, it will come in preliminary hearing.
My lord, serial.
That I'll accommodate.
My lord, serial number 75, it may be recorded in the order, my lord, because later the clerks will not cooperate, my lord. It has happened multiple times. Past 3 dates, it was not.
Serial. On top of the list tomorrow, my lord.
Yeah, the interim order consider ಆಗಿಲ್ಲ. ಅದು preliminary hearing list. List 2 ನಲ್ಲಿ ಹಾಕಿದ್ರೆ.
Grateful, my lord.
Serial number
69, my lord, again I have
tomorrow.
received the notice, my lord.
Court of
Serial number
Let us see. Serial number 52 tomorrow.
Next 2-3 days, whatever is possible, next 2-3 days, I will repeat it. Huh?
My,
Fresh matters avoid.
my lord,
Fresh matters.
my lord, list 1, serial number 18, my lord. On last occasion, my lord was inclined to pass an order. I don't have an interim stay. 2.5 crores of my ITC has been blocked, my lord. May it be listed on fresh matters on Tuesday, my lord. Serial number 18, list 1. Fresh matters on Tuesday or Wednesday, my lord.
Wherever interim order is not considered, you can make a request. I'll ask, let it come in the fresh
Fresh
matters.
matters. Much obliged.
Madam.
Lord, 50.
Utter note with date.
Lord, may I make mention of list 2 serial number 76? Any date next week, my lord?
Court officer will give, I've instructed.
Oblige, my lord.
ನಾನು ಅವ್ರು ಬಂದು ಹೇಳ್ಬೇಕು ಅಷ್ಟೇ ಹೇಳಿ